inherent in each individual as an intrinsic and inseparable part of the human element, which dwells within, as rightly said by Honorable Chief Justice of India, D.Y. Chandrachud. Namaskar. A very beautiful and sunny good morning to our Honorable Chief Guest, respected guest of honor, keynote speaker, our Deputy Pro-Vice Chancellor and Director, Amity Law School, and other invited dignitaries and delegates. I, Anupriya Yadav, Assistant Professor, Amity Law School, Amity University, Lucknow campus, welcomes you all in National Seminar on Right to Privacy and Data Protection in Digital Era, Issues and Challenges. The Arthashastra prohibits entry into another's house without the owner's consent. In Christianity, we find the inspiration to live without interfering in the affairs of others. Religious and social customs affirming privacy also find acceptance in our Indian laws. The right to privacy is not only been documented in Indian scriptures and texts, but has also been acknowledged in various international treaties. In India, this prerogative has been recognized as an intrinsic element of right to life and personal liberty. Hence, this seminar is a premier interdisciplinary platform for researchers, practitioners, academicians to present and discuss the most innovative trends and concerns, as well as practical challenges being encountered. We again welcome you and thank you for participating in this two-day national seminar. We welcome you. Next, we will begin with the lamp lighting ceremony. Light and brightness have always been equated with positivity, motivation, harbinger of good, and associated with spiritual wealth. To start as of the event on this auspicious note, we would like to have the lamp lighting ceremony followed by Ganesh Vandana. To begin with, may I start with inviting our Honorable Chief Guest, Professor Dr. Sudhir K. Bhatnagar, Honorable Vice Chancellor, Dr. Ram Manohar Lohia, National University, our respected guest of honor, Dr. Triveni Singh, IPS SP Cybercrime Lucknow, our keynote speaker, Professor Dr. Kirti Saxena, Director Center of Postgraduate Legal Studies, former Head and Dean, Department of Human Rights, School of Legal Studies, Babasaheb Bhimrao Ambedkar University, our Deputy Pro-Vice Chancellor, Wing Commander Dr. Anil Tiwari sir, and Director Amity Law School, Professor Dr. Jayprakash Yadav sir, on the dais for the lamp lighting ceremony. Please bring it on. Thank you, everyone. The lightning of lamp is testament ushering the positive energy for our event. And with this, we have formally inaugurated the proceedings. Next, we have Ganesh Vandana by Sunamya from ASCO Department. Followed with this, we have the felicitation ceremony. Flowers are bound in nature with expressed humility and tenderness of human emotions. They reflect both warmth and welcome. Atithi Devo Bhava. I would now request our Deputy Pro Vice Chancellor, Wing Commander Dr. Anil Kumar Tiwari to present bouquet to our Chief Guest Professor Dr. Sudhir K. Bhatnagar, Honorable Vice Chancellor Dr. Ram Manohar National University. A very warm welcome, sir. Next, I would request Professor Dr. Jayaprakash Yadav, Rector, Amity Law School, to present this afternoon to our guest of honor, Professor Dr. Triveni Singh, IPS, SP Cybercrime. Thank you, sir. I would now request Dr. Rajiv Kumar Singh, convener of the event, Amity Law School, to present this afternoon to our keynote speaker, Professor Dr. Preeti Saxena. We welcome you, ma'am. I would now request Dr. Sasha Mishra, convener of the event, Amity Law School, to present this afternoon to Wing Commander Dr. Anil Kumar Tiwari, sir, Deputy Pro Vice Chancellor, Amity University, Lucknow campus. We welcome you, sir. Thank you. I would now request Dr. Arvind Kumar Singh, sir, Amity Law School, present this afternoon to Professor Dr. Jayaprakash Yadav, Director, Amity Law School. On this occasion, we are going to release the souvenir, wherein a lot of hard work and creativity has gone in making, as it features various research papers, articles, and many more. I would now request all the dignitaries to come forward to release the souvenir. Okay, come on, guys. This calls for a thunder sound of applause. Everyone, please. Thank you all. A warm welcome is the first sign of trusted access. Words of welcome fill occasion with warmth and makes one feel that he is meant to be. I would now request Professor Dr. Jayaprakash Yadav, Director, Amity Law School, Amity University, to deliver a welcome.
Calling to Mother Lord and also joined online. I would like to welcome on behalf of Amity Law School, Amity University, Lucknow, and the entire Amity universe to our honorable chief guest, Professor Dr. Sudhir Kumar Bhatnagar, sir, Vice Chancellor, RMNLU, Lucknow, in the inaugural session of this national seminar. The topic, right to privacy and data protection in digital era, issue and challenges. A hearty welcome to you, sir. I extend my hearty welcome to all of you. It's so wonderful. Sri Triveni Singh, IPS, SP Cybercrime Lucknow, in the inaugural session of this national seminar. A hearty welcome to you, sir. A hearty welcome. I also extend to my hearty welcome to our Deputy Vice Chancellor, Field Commander Dr. Anil Kumar Tiwari, sir, in this campus. A hearty welcome to you, sir. I extend my hearty welcome to Honorable Keynote Speaker, Mr. Dr. Kriti Saxena, Director CPGLS and ex-Head Dean Department of Human Rights of Babasaheb Bhimrao Ambedkar, Lucknow. A hearty welcome to you, ma'am. I extend to my hearty welcome to Honorable guest Professor Asad Malik, Professor Department of Law, Jamia Millia Islamia University, Delhi. A hearty welcome to you, sir. I extend to my hearty welcome to all the delegate participants across the area, joined in physical mode and on online mode in this seminar on the topic right to privacy and data protection in data protection in digital era issuing challenge. So far as the national seminar of right to privacy, data protection in digital era issuing challenges. If you talk to the first part, that is right to privacy. When I did join of UDHR, mentioned that global share is subject to arbitrary interference with his privacy, family, home, or correspondence, not to attack upon his honor and reputation. Everyone has right to protection of law against such interference or attack. It is very exhaustive in terms of inclusion of every dimension of right to privacy in international law. UDHR declarations took place on 10 December 1948. At that time, framing of the Indian constitutions was in progress. The constitution standard. However, it is ununderstandable that why the right to privacy could not find place in Part 3 and Part 4 of the Indian constitutions under justice civil and non-justice civil category. It is beyond the imagination. There are so many rights like right to education to be a part of non-justice civil rights is also directly or indirectly borrowed from UDHR. Right to privacy is not to be a part of either category. However, under the Article 21 of the Indian constitutions, which is stated, no person shall be deprived from his life and personal liberty except procedures established by law. So here are the two terms which can be at the right to privacy, that is life. Life have various aspects, and the another one is that personal liberty. Later on, the first time in the year of 1954, in the case of MP Sharma case, the Supreme Court had the opportunity to include or recognize right to privacy as a fundamental right under Article 21. But judiciary did not take the example of advantage of this opportunity, and right to privacy did not be a part of Article 20 under the Article 20. Later on, Khalak Singh case. In Khalak Singh case, versus state of UP, when the so many dimension of domiciliary visits was allowed, that the domiciliary visit may not be, domiciliary visit is actually infringe the constitutional provision, or it is unconstitutional by the Supreme. Open the window, right to privacy part of Indian constitution. Then finally, by the ninth event, in Puttaswamy case, it was held that the right to privacy is a fundamental right. So it is a paradigm shift from the MP Sharma to but this is the steps or proactiveness of the judiciary. The parliament have to play its own role, and I'm hoping that in coming days, right to privacy and data protections will be able to place fundamental right under the constitution. We are waiting because we all are the witness of or the victim of unwanted call. Unwanted call, unwanted mails. We all are facing on daily basis. So such types of the things, how the callers, the emailers get our numbers and the email. Obviously, our data is not protected. So therefore, it is a demand now that right to privacy and data protection should be protected and should be parliament take in consideration and make law. Recognize the right to privacy in full-fledged form. So with this, I would like to terminate my welcome address. Before I leave the podium, I once again welcome all the dignitaries to join us in physical mode or who join us in virtual mode. Thank you very much.
Thank you so much, sir. As in the sequence of our minute to minute, our guest of honor, respected Professor Dr. Trivedi Singh sir, has to leave as he has taken out the time from his busy schedule. So, ladies and gentlemen, I am profusely elated to take an opportunity to introduce Professor Dr. Trivedi Singh, IPS SB Cybercrime Lucknow sir, as a guest of honor with us today. Professor Singh is India's first cyber cop. He has investigated more than 200 types of cybercrimes, followed by arrest of thousands of criminals and has solved cases over thousands of crores of fraudulent money. Sir is more popular as a cybercrime investigation specialist and is widely known as Cyber Cop of India. Professor Singh is in charge of investigating cybercrime cases as well as providing administrative and technical supervision to 18 cybercrime police stations located at all commissionerates in the state of Uttar Pradesh. He is also the resource person for various central investigating agencies such as CBI, National Police Academy, Hyderabad, and Institute of Chartered Accountant of India, as well as different state judicial training centers, police training academies, and universities. Popular as a cybercrime investigation specialist with an intensive technical investigation process, Professor Singh is known for his expertise in handling financial and banking frauds. During his distinguished career, he has wide exposure in dealing with cases related to anti-corruption, vigilance, economic offenses, money laundering, and cybercrimes. Among the notable cybercrime cases he had solved, including bursting online fraud of rupees 3,700 crore or by Ablaze Info Solutions, bursting Jamtara's fake call network, cracking a blind murder, arresting a gang, duping people with stealing bank details, and cloning SIM. Professor Singh has been honored with several distinctions, including President Medal for Gallantry by the President of India and Certificate of Honor by Director CBI. He was also conferred with India's Cyber Cop of the Year Award 2012 by DSCI NASCO. He has been awarded at various national and international platforms for his contribution to control cybercrime. It's a well-known proverb that action speaks louder than words, but sir, definitely your words are also going to motivate our students and enlighten us. So I would now request our guest of honor to please come up on the dais by sharing experience and knowledge.
नमस्कार। आज का टॉपिक बहुत ही इम्पोर्टेंट टॉपिक है, राइट टू प्राइवेसी एंड डेटा प्रोटेक्शन। सब कुछ डिजिटल डेटा है आज की डेट में, आप जानते हैं। इवन हमारी आइडेंटिटी भी डिजिटल है और पूरा आपका पैसा भी डिजिटल है। आप देखिए अभी हम लोगों ने एक केस यहाँ क्रैक किया था 146 करोड़ रुपीस, जो बदमाश है 146 करोड़ रुपए को ट्रांसफर कर दिया विद इन मिनट्स अपने अकाउंट में। अभी लखनऊ का ही केस है, 2-2.5 महीने पहले आप लोगों ने देखा होगा। किसी की कोई भी आइडेंटिटी बना ले रहा। अब डीप फेक टेक्नोलॉजी आ गई। डीप फेक टेक्नोलॉजी से क्या है, आप देख लीजिए कितने तरह के क्राइम हो रहा है। आपकी आइडेंटिटी, आपकी कोई आवाज अगर 2 मिनट के लिए हमको मिल जाए या 30 सेकंड्स का मिल जाए, तो हम डीप फेक टेक्नोलॉजी यूज करके सिंथेटिक वीडियो बना लेंगे। तो अगर मेरा जैसे भी आपने 30 सेकंड्स मेरा ले लिया, तो अब हमारा सिंथेटिक वीडियो कुछ भी बना दीजिए, जो मन में आए वो वीडियो बना दीजिए, क्योंकि हम ऐसे बोल रहे हैं, सिंथेटिक ऑडियो बन जा रहा है। और आपको ये भी बताया कि फॉरेंसिक कैपेबिलिटी अभी हमारी इस तरह की नहीं है कि मैं तुरंत बता दूं कि आर्टिफिशियल इंटेलिजेंस मशीन लर्निंग यूज करके ये डिफेक्ट जो वीडियो बनी है या ऑडियो बना है ये सिंथेटिक है। तो अगर किसी पॉलिटिशियन का, किसी बड़े सीनियर ब्यूरोक्रेट्स का अगर डीप फेक घूमने लगे, या किसी का भी आपकी पर्सनल लाइफ में आपकी डीप फेक बना दिया जाए, जैसे कोई कहने में वो नहीं है, सारे लोग यहाँ वो है कि आज की डेट में पोर्नोग्राफिक में 90% डीप फेक चल रहा। आप देखते हैं ये सेलिब्रिटी, वो सेलिब्रिटी, उनका केवल फेस ले लिया, डीप फेक बना दिया, पूरी वीडियो चल रही है, पूरा ऑडियो चल रहा। ये थ्रेट्स हैं आज की डेट में। ये थ्रेट्स है कि आप अपना मोबाइल फोन लिए हुए हैं, आपका मोबाइल फोन हैक हो जाएगा, आपका अकाउंट बदमाश ऑपरेट करेगा और पूरा का पूरा आपका पैसा चला जाएगा। ये मतलब कहानी नहीं बता रही कि सारा कुछ हो रहा है, जो मैं केस इन्वेस्टिगेट करता हूँ वो मैं बता रहा हूँ आपको कि पूरा का पूरा अपना अकाउंट कॉम्प्रोमाइज कर देंगे, रिमोट एक्सेसफुल डाउनलोड करा देंगे, आपका ओटीपी पढ़ते रहेंगे, ओटीपी नहीं पूछेंगे, और पूरा आपका यूपीआई प्लेटफॉर्म जो ऑपरेट करेंगे पूरा का पूरा पैसा गायब कर देंगे। आप देख लीजिए कोई एक डीप फेक, कोई पहले मार्फिंग हुआ था, मार्फिंग सिंपल सी टेक्नोलॉजी है जिससे हम फोटो मार्क करते थे। अब आर्टिफिशियल एआई कहाँ लेके चला गया डीप फेक टेक्नोलॉजी को कि अब तो कुछ भी करने की जरूरत नहीं, आपका एक फोटो लगाएंगे, एक आपकी फेसबुक पे आईडी क्रिएट करेंगे और पता नहीं क्या करना शुरू कर देंगे। फर्स्ट से जब इन्वेस्टिगेशन शुरू होगा तो पुलिस आपको पकड़ेगी क्योंकि आपकी आईडी है, आपका चेहरा है। बाद में इन्वेस्टिगेशन होगा, डीपर इन्वेस्टिगेशन होगा तो पता चलेगा कि नहीं किसी और ने बनाया था, ये तो बात की बात है। लेकिन फर्स्ट साइड तो आप ही जाएंगे, आपके नाम पे। आप देखिए, आपको पता भी नहीं है इसमें प्रीपेड कस्टमर्स कितने हैं जो मोबाइल फोन के प्रीपेड, हाथ उठाइए जिनके पास प्रीपेड मोबाइल है। अब देखिए करीब 90% लोगों के पास प्रीपेड नंबर है। अब 90% लोगों के पास प्रीपेड नंबर, कैसे पता कि वो नंबर जो आप यूज कर रहे हैं वो आपके नाम पे है? कोई बताए कैसे पता कि वो नंबर आपके नाम पे है? नहीं, मैं आपको बता रहा हूं कि लोगों को जानकारी ही नहीं है। जो आप रिटेलर्स के पास जाते हैं, मैं सबकी बात नहीं कर रहा हूँ, ज्यादातर रिटेलर्स आपको जल्दी से करा करके आपको दे देते हैं कोई भी प्रीपेड। ज्यादातर लोगों का प्रीपेड जो है उनको पता ही नहीं है किस नाम से, क्योंकि जब आपका आधार कराएगा तो वो बाद में वो जनरेट होगा, पहले से प्रीपेड सिम आपको दे देगा एक पकड़ा दो, और कोई तरीका नहीं है जानने का कि ये किसके नाम से चल रहा है जब तक पुलिस न चाहे। आप चाहेंगे तो आपको पता नहीं चल पाएगा क्योंकि बिल आना नहीं है, तो एड्रेस का भी पता। अब इस तरह से कितने क्राइम हो रहे हैं पूरे इंडिया में सिर्फ इसी की वजह से। नाम किसी और का, क्राइम कोई और कर रहा है। आप देखिए क्राइम करने का एक सिंपल तरीका बता रहे हैं आपको हाथ उठाना। आप में कितने लोगों को मैसेज आता है कि पार्ट टाइम जॉब के लिए आप अगर आप विलिंग हो तो आप टीसीएस में, विप्रो में और बड़ी बड़ी कंपनियों में पार्ट टाइम जॉब के लिए ऑफर आया, 50,000 रुपीज पर मंथ मिलेगा, 40,000 मिलेगा। कितने लोगों का मैसेज आता है? कभी आता है, कभी क्या रोज ही आता है ना। और सुनिए, अब मैं आपको बता रहा हूँ सबसे इंटरेस्टिंग बात। एक बरेली की लड़की को आया मैसेज पार्ट टाइम जॉब पे वो व्हाट्सएप मैसेज था, उसने कनेक्ट किया तो टेलीग्राम का नंबर मिला। टेलीग्राम पे एक यूआरएल था, उसको क्लिक किया तो एक फर्स्ट क्लास का डैशबोर्ड बन के आया एक वेबसाइट का। उस पर पॉन्जी स्कीम चल रहा था, लड़की लालच में आ गई, उस पॉन्जी स्कीम में उसने पैसा लगाया और पैसा लगाने के बाद 2.5 लाख 2,20,000 रुपये उसके गए। उसने हमको कनेक्ट किया, मैंने उसको केस को इन्वेस्टिगेट किया। ध्यान से सुनो, 2.2 लाख उस बच्ची ने किया, उसका पैसा गया। और जब इस केस को मैंने क्रैक किया तो 4,200 करोड़ रुपीज का स्कैम था। 4,200 करोड़ रुपीज। और ये पैसा कहाँ जा रहा था? ये पैसा जा रहा था चाइना। अब देखिए ये डिजिटल, हम डिजिटल इकोनॉमी की बात कर रहे हैं, अच्छी बात है। डिजिटल ही ऐसा है कि अगर हम डिजिटल ट्रांसफॉर्मेशन की बात कर रहे हैं, ये डिजिटल क्या है कि हमारी जिंदगी को, हमारी इकोनॉमी को, हमारा पूरा बिजनेस प्रोसेस को, सब कुछ इतना फैसिलिटेट कर दिया कि हम इसके ऊपर डिपेंडेंट हो चुके हैं। और इसका मिसयूज क्रिमिनल्स कैसे, मैं पुलिस अफसर हूं, मैं केवल क्राइम के एंगल से किसी भी प्लेटफॉर्म को देखता हूं, तो इसका मिसयूज कैसे किया। चाइनीज जिनकी उम्र थी 18 से 25 साल, वो लड़के वहीं से जो बल्क एसएमएस भेजा जाता है, जो आपको मिलता है, चाइना से ऑपरेट कर रहे हैं। बल्क एसएमएस जो प्रोवाइडर है उसका पोर्टल का एक्सेस रिमोटली लेके वहां से, प्लस इंडियन पुलिस को ये पता ना चले कि ये चाइना से ऑपरेट हो रहा है। उन्होंने अमेजन क्लाउड लिया इंडिया में, अमेजन क्लाउड पे एक वर्चुअल मशीन क्रिएट किया ताकि वर्चुअल मशीन से हम ये काम करेंगे। तो आईपी कहाँ की आएगी, पुलिस को क्या पता चलेगा कि ये आईपी इंडिया की है, पुलिस के लिए वो हमेशा के लिए चाइना जो है। और उन्होंने क्या किया, एक नोडल अकाउंट खोला आईसीसी बैंक में, और जो फिनटेक कंपनियां रेजर पे होगा, इनसे वर्चुअल अकाउंट लेकर के सबको पैसा, जैसे आपको मैसेज आता है, आपको कहीं पैसा देना होता है, एक वर्चुअल अकाउंट नंबर आपको दे दिया जाएगा। तो एक नोडल अकाउंट के अगेंस्ट में हजारों वर्चुअल अकाउंट इंडिया में घूमने लगे। अब वो हजारों जगह से एक अकाउंट में पैसा आ रहा है, चाइनीज जो आईसीआईसी बैंक का नोडल अकाउंट हो उसको एक्सेस चाइना से कर, वहां से पैसा भेज रहा है। आप क्रिप्टो करेंसी के बड़े शौकीन है, जेपे में भेज रहा, जेपे क्रिप्टो करेंसी में, ये पैसा क्रिप्टो करेंसी में कन्वर्ट किया, फिर वहां से बिनांस आप जानते होंगे, बिनांस जो क्रिप्टो करेंसी प्लेटफॉर्म है इंटरनेशनल, वहां पैसा भेजा, वहां से एक टूल होता है जिसको हम लोग बोलते हैं, वो क्या बोलते हैं उसको, जो हजारों वॉलेट्स में उसको भेज देता है वहां से, मिक्सर टेक्नोलॉजी यूज करके। जब हम लोगों ने इन्वेस्टिगेट किया, 4 महीने 5 महीने लगे इन्वेस्टिगेशन में, तो पता चला कि ये पूरा का पूरा गैंग ऑपरेट कर रहा है चाइना से। 4200 करोड़ रुपीस आपको सिर्फ 10,000 20,000 दिख रहा, लेकिन आप पैन इंडियन सोचिए, लाखों मैसेज लोगों को डिलीवर हो रहे हैं, वो लाखों में अगर 2%, 3%, 4% भी अगर शिकार हो गए, तो आप सोचिए कितना बड़ा मैग्नीट्यूड है क्राइम का। 4200 करोड़ रुपीस, ये जो 156 करोड़ रुपीस लखनऊ के बैंक से बदमाश अपने अकाउंट में ले गए, 146 करोड़ रुपए, उसमें बदमाशों ने की लॉगर यूज किया था, की लॉगर यूज किया था, और प्लस रिमोट एक्सेस टूल डाउनलोड कर दिया था, और एक नया लैपटॉप उस स्विच में ले जाकर के उसी नेटवर्क पे डाल दिया था, बाहर से बैठ करके बैंकिंग ऑपरेशन कर रहे थे। अब सोचिए, एक बैंक का पूरा ऑपरेशन बदमाश अपने कमरे से कर रहा है, 146 करोड़ रुपए अपने अकाउंट में लेके चला गया। सोचो आज के जमाने में ये किसी और कभी किसी टाइम हो सकता था। 146 करोड़ रुपीस की करेंसी लेना पड़ेगा तो आपको ट्रक लगवाना पड़ेगा या बस लगवाना पड़ेगा। भाई मैक्सिमम करेंसी का क्या हुआ, 2000 रुपीस की करेंसी हो, तो 146 करोड़, तो फिर भी पता नहीं कितना पैसा होगा। अब क्या है, विद इन फ्रैक्शन ऑफ सेकेंड वो पूरा का पूरा पैसा चला जा रहा है। भाई आज 146 करोड़ रुपीस हुआ, किसी और के किसी और बैंक पे कुछ होगा और पूरा का पूरा पैसा चला जाएगा। ये थ्रेट्स है। ये टॉपिक इसलिए इंपॉर्टेंट है कि हम डिजिटल प्रोटेक्शन की बात कर रहे हैं, डिजिटल डेटा प्रोटेक्शन, सब कुछ डिजिटल डेटा है, हम केवल पैसे की बात क्यों करें। हम जो एग्जाम दे रहे हैं वो डिजिटल है, हमारा रिजल्ट है वो डिजिटल है। एक यूनिवर्सिटी में, इलाहाबाद यूनिवर्सिटी का एक केस में कर रहा था, एक इलाहाबाद यूनिवर्सिटी में असिस्टेंट प्रोफेसर का पद क्रिएट हुआ, उसके लिए इंटरव्यू के लिए 18 लोगों को कॉल किया गया। एक प्रोफेसर साहब ने फेक मेल बनाया और रजिस्ट्रार का फेक मेल, स्पूफ मेल से सारे कैंडिडेट को एक मेल कर दिया कि इंटरव्यू पोस्टपोन, और जिस दिन इंटरव्यू था अकेले पहुंच गया, और अकेले पहुंच गए तो उन्होंने कहा कि अकेले मैं पहुंचूंगा तो मेरा सिलेक्शन हो जाएगा, क्यों एक ही वैकेंसी थी। तो उन लोगों ने कहा कि एक किससे मेल आया, तो पता चला कि रजिस्ट्रार जो है इलाहाबाद यूनिवर्सिटी से मेल आया हुआ है। तो वो केस हमको दिया गया, तो मैंने इन्वेस्टिगेट किया, फिर एक को अरेस्ट किया उसमें। तो मैंने कहा क्यों किया तुमने, कहा सर नौकरी मिल नहीं रही है। मैंने सोचा 18 लोग में पता नहीं चांसेस होंगे क्या नहीं, तो हमने स्पूफ मेल क्रिएट किया, रजिस्ट्रार के बिहाफ पे मेल सबको भेज दिया, और भेजने के बाद मैं अकेले पहुंच गया इंटरव्यू के लिए, मेरा सिलेक्शन होना ही था। ये देखिए, ये वो स्पूफ मेल को कोई भी नेकेड आई से नहीं बता सकता। आप उसकी हेडर की एनालिसिस करेंगे, फॉरेंसिक करेंगे, 10 जगह से डेटा मंगाएंगे, तब आपको पता चलेगा एक फेक मेल है। आज का स्पूफिंग का एज है, हम आपका नंबर तुरंत स्पूफ कर लेंगे, आपकी मेल आईडी तुरंत स्पूफ कर लेंगे, आपकी आईडी स्पूफ कर लेंगे, आपका बैंक अकाउंट क्लोन बना लेंगे, बायोमेट्रिक। हम लोगों ने डेटा रेड किया करीब 10-12 लड़के खाली इसकी क्लोनिंग बना रहे थे, हजारों लोगों के अंगूठे की क्लोनिंग, डिजिटल क्लोनिंग बना करके पैसा निकाल रहे थे बैंक। अब सोचिए, अब बायोमेट्रिक क्लोनिंग हो गई, एक बैंक में पकड़ा हुआ आपका डेबिट कार्ड का क्लोन कार में बैठ के बना, कार में बैठ करके डेबिट कार्ड क्रेडिट कार्ड का क्लोन बना रहे हैं। अब सोचिए, अब बड़ा सिंपल सा है, आप तरीका नहीं बताऊंगा, नहीं तो ये बहुत बच्चे जो है उसी में दिमाग लगाने लगेंगे। लेकिन मैं ये कह रहा हूँ कि आपका डेबिट कार्ड, आपका क्रेडिट कार्ड, आपका मोबाइल फोन की ईमेल चेंज कर दे रहे हैं। मैं बरेली में स्पेसिफिक था, एक गैंग करता था क्या काम, मोबाइल चुराता था, तुरंत फ्लैशर टूल यूज करता था, मोबाइल की ईमेल चेंज करता था और आपके सामने यूज करता था। आप कहिए कि मेरा मोबाइल फोन है, अरे कैसी बात कर रहे हैं, ऑथेंटिकेट करा लीजिए। जब ऑथेंटिकेट करेंगे तो मोबाइल का आईपीआई ही एक तरीका होता है चेंज वो करने का, तो आईपीआई चेंज, क्योंकि फ्लैशर टूल है। अभी एक मेरठ का केस था जिसमें एक ही आईपीआई और 1000 मोबाइल नंबर यूज हो रहा है, सोचिए। तो जब ये स्पूफिंग का एज है, हम आपका मैक आईडी चेंज कर दे रहे हैं कंप्यूटर का, हम आईपीआई चेंज कर दे रहे हैं, हम सब कुछ चेंज कर, जब इस तरह की दुनिया हो जाए स्पूफिंग, जब ये दुनिया हो जाए तो खतरे कितने होंगे, अब आप सोचिए कितने होंगे। आपको एक और हकीकत बनाना है, जैसे आप naukri.com पे जाते हो और अपनी प्रोफाइल जैसे आप फिल करते हैं वैसे ही ये ब्लैक मार्केट में चला जाता है, उसी दिन इवनिंग में ये ब्लैक मार्केट में चला गया। अब आपको एक फोन आता है, कांग्रेचुलेशन, यू हैव बीन सिलेक्टेड फॉर सच एंड सच पोस्ट इन विप्रो टेक्नोलॉजी, और आई कैन सी फ्रॉम योर प्रोफाइल, बोलते हैं उनको पूरा स्क्रिप्ट लिखा, आई कैन सी फ्रॉम योर प्रोफाइल दैट योर प्रेफर्ड लोकेशन इज ग्रेटर नोएडा एंड द पोजीशन यू आर लुकिंग फॉर इज सिस्टम एनालिस्ट। और ये तो आपको लगेगा हाँ सही है, क्योंकि वो तो ही इज रीडिंग इट फ्रॉम योर बायो जो आपने फीड किया हुआ, और उसके बाद आपको लगेगा कि ये naukri.com के हेडक्वार्टर से आ रहा है, जबकि फैक्ट है कि क्रिमिनल्स के पास आपका डेटा है, वो बाकायदे कॉल सेंटर बनाए हुए हैं और वही आपकी प्रोफाइल पूरा रीड कर रहा है। और आपको ये भी कहेगा कि आपकी एक्सपेक्टेड सैलरी आप 5 लाख या 3 लाख या 15 लाख ले रहे हैं। आपको ये भी बताएगा कि ये कंपनी है, वो क्या काम करते हैं, आईटी कंपनियों की एक जगह, अगर आपने सिविल में किया हुआ है तो सिविल की बड़ी कंस्ट्रक्शन कंपनियों के एक जगह नाम लिखे रहते हैं, अगर आपने एमबीए फाइनेंस किया हुआ है तो फाइनेंस से बड़ी बड़ी कंपनियों के नाम लिखे हुए हैं। अब फाइल पढ़ा, उसने कहा ये फाइनेंस का है, अब वो फाइनेंस की बड़ी बड़ी कंपनियां जो है उनके नाम लेना शुरू कर दिया, टाटा फाइनेंस, ये फाइनेंस, आईसीटी बैंक, एचडीएफसी बैंक। अगर उसने प्रोफाइल देखा कंप्यूटर तो कंप्यूटर इधर विप्रो और ये और वो पढ़ना शुरू कर, आपको लगता है ये कॉल सही है, आप के शिकार हो जाते हैं। तो ये क्या है, ये जो हम डेटा प्रोटेक्शन की बात कर रहे हैं, अभी हमारा डेटा प्रोटेक्शन एक्ट बनने वाला है, अभी जो हमारा इंफॉर्मेशन टेक्नोलॉजी एक्ट है 2008, उसमें उस तरह के प्रोविजन नहीं है कि आपको इंस्टेंट रिलीफ मिले। लेकिन अब जब हमारा डेटा प्रोटेक्शन आ जाएगा, पर्सनल डेटा प्रोटेक्शन बिल जो अभी पेंडिंग है, अगर वो हो जाएगा तो हम ढेर सारी चीजों पे काम करने लगेंगे। जैसे आप जीडीपीआर देखिए, यूएस यूरोपियन कंट्री का जीडीपीआर, जो जनरल डेटा प्रोटेक्शन रेजिम है वहाँ रेगुलेशन, वो अगर आप यूरोप से कोई अगर आप बिजनेस करना चाहते हैं तो आपको जीडीपीआर कंप्लाई करना पड़ेगा। उसी तरह हमारा ये भी आ जाएगा। आप यूएस में देखिए हिप्पा एक्ट चलता है, हमारा हेल्थ प्रोफाइल सेंसिटिव डेटा, ये पब्लिक डोमेन में नहीं जाना चाहिए। आप सबका पब्लिक डोमेन में हेल्थ डेटा पड़ा हुआ है, इसलिए कि हमारे यहाँ उस तरह का एक्ट नहीं है। अगर हिप्पा जैसा एक्ट इंडिया में भी आ जाए तो हम ये कहने लगे कि हाँ ये तो सब मिलाकर ये जो है कि आज की डेट में डिजिटल थ्रेट्स, आप चाहे जो भी नौकरी करते हो, आप चाहे जो करते हो, लेकिन जो ये साइबर रिस्क है, जो डिजिटल थ्रेट्स है, ये जरूर पढ़ा, क्योंकि जब मॉडस ऑपरेंडी जानेंगे एक बदमाश कैसे क्राइम करता है तभी आप सतर्क रहेंगे। टेक्नोलॉजी जानने से कुछ नहीं होगा, कानून जानने से कुछ नहीं होगा, जानिए तो आपकी नौकरी की जरूरत है, लेकिन आपको ये जरूर जानना पड़ेगा कि ये बदमाश क्राइम कैसे कर रहा है। अब आपको यही नहीं पता कि एईपीएस में, आधार इनेबल पेमेंट सर्विस में, आपका केवल अंगूठे का क्लोन मिल जाए तो 10,000 रुपया रोज निकालेगा, ओटीपी की जरूरत नहीं। अगर आपको इतना सा पता हो जाए कि क्यूआर कोड जो आता है हम स्कैन करेंगे तो पैसा देने के लिए होता है, लेने के लिए नहीं होता क्यूआर कोड की स्कैन, ये इतनी सी छोटी सी जानकारी अगर आपके पास हो जाए तो आप कितना बच जाएंगे कि क्यूआर कोड मैं स्कैन करूंगा तो 2 वे नहीं होता, 1 में होता, पैसा देने के लिए होता है। बदमाश यही करते हैं, साहब मैं आपको पैसा देना है, आप ये क्यूआर कोड स्कैन कर दीजिए, आपको इतना पैसा मिल जाएगा। जैसे आप स्कैन करते हो पैसा चला जाता है, आप आपका अंगूठा लगा कर 10,000 रुपया निकाल दें। बहुत सी चीजें आपको जानने, मॉडस ऑपरेंडी बदमाश आज की डेट में डिजिटल क्रिमिनल जिनको बोल रहे हैं। देखिए रैंसमवेयर अटैक हो रहा है, मालवेयर से अटैक कर रहे हैं। आप कितने लोग, अगर मैं पूछूं कि आप कितने लोग इसमें बता सकते हैं कि आपका मोबाइल फोन कंप्रोमाइज नहीं है, इसमें कोई मालवेयर नहीं है, इसमें कोई स्पाईवेयर नहीं है, इसमें कोई रैंसमवेयर नहीं है, ये कितने लोग लाभ दे सकते हैं? अगर मैं पूछूं कि यार कितने लोग सिक्योरिटी पे, डिजिटल सिक्योरिटी पे सीरियसली सोचते हैं, कितने लोग सोचते हैं? नहीं, हमको इससे मतलब ही नहीं, हम तो बस इसको यूज कर रहा है, लेकिन इसकी सिक्योरिटी के बारे में कौन सोचे? थैंक यू।
Thank you so much, sir. I think everyone would not mind if we fall in the sangam of the cyber world. Thank you so much, sir. Thank you, sir, for enlightening our students and motivating our students with your words. And definitely, with your words, we can also find the next cyber talk from our department also, from our students also. Thank you so much, sir. Appreciation is a wonderful thing. It makes what is excellent in other belongs to us as well, as rightly said by the auditor. Since sir has to leave out of his busy schedule, I would now request Professor Dr. Jaiprakash Yadav, Director, Amity Law School, Amity University, to present the memento to our guest of honor, Professor Dr. Triveni Singh, sir. He is a man of distinct vision and a fountainhead of illuminating ideas, an idol of knowledge, experience, and inspiration to all of us. We admire your spirit of integrity with 100% dedication to the world of education. You are an inspiration to many of us. I would now request Wing Commander Dr. Kumar Tiwari, sir, Deputy Pro Vice Chancellor, Amity University, Lucknow campus, to deliver his address.
Most respected Chief Guest, Honorable Vice Chancellor, Subir Bhatnagarji, Professor Triveni ji in absentia because he had to leave in hurry, Professor Dr. Preeti Saxena ji, Professor Dr. Asad ji, Professor Dr. J.P. Yadav, my faculty colleagues and dear students, a very good morning and a warm welcome to this wonderful national conference that is so apt and so interesting. These warm welcome is not only to my all guests on my personal behalf, but also on behalf of our Honorable Founder President, Dr. Ashok K. Chauhan, whose vision and foresight has made such events possible. These good wishes are also from our Honorable Chairman, Dr. Aseem Chauhan, whose great vision we are living today. These greetings are also from our Honorable Vice Chancellor, Professor Dr. Balwinder Shukla, an outstanding academician who has dreamt of Amity University reaching world standards. The topic that has been spoken by Triveni Singh ji, that is right to privacy and data protection in digital era, is just giving a window of glimpse to you how important the issue is. I'll just give you one example to extend it further so that you are better sensitized to be active participant in this national conference. 2 days back, I had sent a WhatsApp message to your organizers, which said, Chat GPT-3 passes US law examination. Now, what is it? It's an AI-based tool. It learns from everywhere, and then it's kept in a silo. And it is given a paper which is given to another examiner. The software replies back and it is given to an examiner. And there is no way examiner can judge that it is by a human being or by an AI software. So it passes the exam. And day 2, it will become a legal advisor. If it has passed LLM, if it has passed BA, LLB, and by God's grace, it's cleared, PhD also, which is very much possible. Technology, I know very well, being an engineer. It will become a professor next day. This is not fiction, this is reality. Sir spoke, Triveni Singh, she spoke about, you lead 2 lives. One is in the physical world, another is in the cyber world. If your life in the cyber world is compromised, it will certainly affect your physical life. And that is where advanced privacy and data protection regulations become so very important. And let me tell you, still, this is the tip of the iceberg. You must have heard of the famous inventor and scientist and engineer Elon Musk. Elon Musk is trying with the technology where it will be possible for him to install a chip in the human brain by a company called Neuralink. And it's not fiction, it's a fact. Just within half a decade, it will be possible to download all human memories and thoughts to a machine and retransmit back to the human being in order to save him from diseases like Alzheimer's, schizophrenia, disability. It's a medical tool which will be able to do. But just remember, who owns those thoughts? Who owns those memories? These are the challenges of the future where lawyers like you will have to. And my request is, please think interdisciplinary. You heard Dr. Triveni Singh. You really couldn't make out whether he's a lawyer, he's a computer science expert and an IT expert. So that's the future of a lawyer going to be. And towards that, I would request all of you to talk to your friends across and enhance the knowledge. Invite them across to these conferences so it can multiply and you can do wonders that you are going for. Great having my presence in this national conference. I wish you all the best. God bless you all. Jai Hind.
Thank you so much, sir, for pestering us with your illuminating ideas and words of wisdom. We are extremely privileged to have a renowned and distinguished personality, Professor Dr. Preeti Saxena, Director, Center of Postgraduate Legal Studies, former Head and Dean, Department of Human Rights, School of Legal Studies, Babasaheb Bhimrao Ambedkar Central University, with us as a keynote speaker. Ma'am, we welcome. Ma'am is an eminent scholar of constitutional law, administrative law, torts, constitutional governance. Ma'am holds a doctorate in law from Kumar University and her bachelor's of law and LLM from Rohilkhand University. He is gold medalist in her master's. She has a teaching experience of 31 years and research experience of 28 years. Furthermore, ma'am has been awarded with various prestigious awards, honors, and accolades. Besides this, ma'am has also been awarded with the Prashasti Patra from Ministry of Youth Affairs and Sports Government of India, organized by Nehru Yuva Kendra. Furthermore, ma'am has published around 65 papers in journals of national as well as international repute. She has supervised more than 150 LLM students and has guided 15 research scholars. Ma'am has also won membership of various professional and academic bodies such as NAT and Bar Council of India. Ma'am has also authored and edited various books. So without much delay, may I have the pleasure of inviting a dynamic speaker, Professor Dr. Preeti Saxena, ma'am, to take over the forum and
Good morning to one and all. So first of all, I would like to congratulate Professor J.P. Yadav and his team, the convener of this seminar, Dr. Rajiv and Dr. Sasha, for convening this national seminar on a very, very contemporary, apt and never-ending topic. That is the right to privacy and data protection in digital era issues and challenges. I've heard three previous speakers, including Dr. Yadav, and they have seen this topic with their own lens of work. One from the constitutional law angle, other from the cyber expert angle, and the third one from the engineering angle. So the lenses are different, but the point is the same. That is how to make ourselves so that we can be able to secure ourselves, to save ourselves, to maintain our privacy in this digital era. Now, as the topic suggests two things, one that is right to privacy, and the other is the data protection in the digital era. Issues and challenges are always. So, being a student of constitutional law, I would say that privacy or right to privacy, that is the concept which is very, very near to everybody's heart. And this is not a new concept, that the privacy, that is the demand for every human being from time immemorial. And being a student of law, we must think over that where from this right to privacy has emerged or taken the shape of law. So if we talk about the Greek period, then we find that they were having this privacy in their law, and they were having this as one's own property, one's own life. And in that, they find that the privacy is always there. If we talk about the Roman concept of this privacy, then they say that privacy is something which is the temporary refuge from res publica, that you are making yourself within you and you are not allowing anybody to enter into your own life. That is, the public should be not in your life. That is your right to privacy. If we see in our own concept, Indian context, then we find that our Hindu law always recognizes this right to privacy, whether this is belonging to the home or family affairs or something else. And then we find that in our own culture, Hindu law also recognizes that. And as I can see Asad here, then I will also talk about the Islamic law, that this concept was always very much recognized in Islamic law also, like fiqh. Am I correct, Asad? So fiqh, that was also considered to be the law under the Islamic regime. So if we see that in Indian context, in Greek context, and Roman context, this privacy has always been there as one of the right of the person, so that they may live their own life without the interference of the others. So in all, this is what privacy was there. But if we see European countries and particularly England, then Edward Coke, he once said that in England, everybody wants to be live in his or her own castle, in his own castle. That is, the privacy right was very much demanded there also in England. However, when we talk about the word privacy, whether it is defined or not, it evades any definition. There is no direct definition of privacy in any of these laws which I have just talked about. This is only a concept wherefrom we can have the idea that these countries were having this privacy in one way or the other way. The only idea is that one has to make a no interference zone within his or her own personality, security, safety, or property. So it was working like in different manners. And when we talk about the English law, then we find that the law of torts, that speaks about the privacy. but that is related to the bodily privacy as well as the property or the territory privacy. So right to privacy was always there in the English law also. Law of torts is the example for that thing. Now, so far as the privacy related to the data is concerned, then we find that everywhere or today in the modern society, we are totally profiled. Profiled in the sense that the earlier speaker also told about you, that we are using many of the gadgets because of the advancement of the technology. Technology is something which we can say is science in action. Technology that has made our life very easy. Technology which is facilitating our life. So everybody is using different gadgets because we are used to feel the easy life, the life which is having so many facilities with us. Regarding protection of data. So why do we need to protect our data? Or what do we mean by the data? That is very important point, which everybody of you as a user of various technologies or you are using various gadgets, you must be aware as to what is data. So any information, anything which we are posting, anything which we are having in our gadgets, any information that is known as the data. Data may be related to your own, any of the information which is related to your health, which may be related to your medical health, which may be related to your education, which may be related to your financial condition, or any of the information that you are filing over the media or the technology, that is your data. So why do we need to protect that data? That becomes very important. And in that, we find that in India, we are lagging behind any of the specific law to protect the data. However, we were having a law since 1860 to some extent to protect our data or to protect our privacy in that sense. For example, if we talk about the Indian Penal Code, IPC, then we find that 509, 354, and after the amendment, 354C and 354D. These are the provisions which speaks about the protection to our privacy. Privacy from whom? Privacy from the others. And at the same time, if we see Article section 441, 443, and 445, then again we find that this is something which is saving ourselves from the privacy of the territory, privacy of the land, that is house lurking or house trespass. So these two things from the law of torts and Indian Penal Code, these are providing for or giving us some type of the privacy and protecting our privacy. But in the era of this digital era, we are feeling that we don't have the laws which can protect our data, which can protect our privacy. Because on the one hand, there is a transparency in the shape of the information which we are given through the using of the technology. On the other hand, we are having this right to privacy. As rightly told that in Indian context, if we find that the Constitution is the supreme law of the land and it has not provided directly for the right to privacy. But if we talk about the international regime, we find that Article 12 of the Universal Declaration of Human Rights that speaks about the right to privacy. And that privacy is related to our family, to our home, to our correspondence, at the same time to our reputation and honor also. So this reputation and honor is nothing but that is something which was already in existence through the law of tort, because defamation that is going down the reputation of one of the person is called to be the defamation in the law of tort. And that is one of the, we can say, extension of right to privacy, which was earlier we were having in the torts regime. And Universal Declaration of Human Rights speaks about under Article 12 regarding the saving of one's person's privacy for family, for home, and for correspondence. Similarly, we see International Covenant on Civil and Political Rights at international level, Article 17, again it speaks in the same words that right to privacy is available to all the persons. Besides this international covenant and the UDHR, GDPR rules are also there, which are related to the European countries, and this is related to the digital protection regulation. And in India, if we come here, then we find that we were having direct law on that is the IT Act, that is the Information Technology Act 2000. And for this data protection, to some extent, there are certain rules of 2011, which speaks about the protection of some of the data. However, when we find about the latest provision regarding the data protection, then we find that in 2022 November, DPDP bill, that is Digital Person Data Protection Bill of 2022, that was introduced, and the comments were sought from the general public for 1 month. It is up to 18 December, and this is the fourth iteration of the Data Protection Act bill, which was introduced first in 2018, then 2019, 2021, and now it is in 2022. So when this bill was introduced on 17th November, it was told that this bill will be put in the budget session of the Lok Sabha in February 2023, but as we see that it could not be passed, and it was not placed before the Lok Sabha in this 2023 budget session. So again, we have to wait for what is coming up as a direct regulation on the data protection or digital protection. However, if we see regarding this right to privacy with the data protection, then we find that privacy is something which was not defined, but right to be let alone. That was one of the statements given by the Right to Privacy book by the American duo, Samuel Warren and Louis Brandeis. So right to be let alone, that is your privacy. While your digital footprints, which are not allowing you to be alone. And this is the issue of contest. This is the one of contest where from this seminar is having its various issues. That on the one hand, we are claiming our right to privacy, which is not given directly by the supreme law of the land, that is the Constitution of India. On the other hand, we are using technology. We are being facilitated by technology. There are different types of the technology, but here we are confined to the communication and information technology. So these technology and the privacy, when it comes in a contrast, then this conflict is giving violation is violating your right to privacy. And why I'm saying that right to privacy is your right, it's only a human right. But because of the interpretation by the Supreme Court of Article 21, it is now declared as a fundamental right. Besides that, the committee which is appointed for the review of the working of the Constitution under the chairmanship of Justice M.N. Venkatacharya, that has also recommended that there should be one insertion of Article 21 Clause B, which should specifically provide for right to privacy in the same terms as it is defined in Article 12 of the Universal Declaration of Human Rights. So that suggestion or recommendation of the Constitution Committee could not be materialized yet, but the journey of interpretation of this right to privacy under Article 21 started since 1954. 1954 was the case of M.P. Sharma, Satish Sharma case, and at that time, the court has not allowed that this is to be brought under Article 21. Right to privacy is not a part of Article 21. Then Khadak Singh case comes in 1967, and the Supreme Court has once again got the opportunity to decide this right to privacy as an extension of right to life, personal liberty under Article 21. But the court has confined itself without going into details whether right to privacy is a part or not. But it said that we are in a democratic nation and that nation demands ordered liberty. So some type of the ordered liberty is to be there. It is not the right to privacy because we are sovereign, we know, but the sovereignty is also having certain aspects, and for that it is required that any of the rights which are there may not be an absolute, maybe not in the absolute terms. And that's why this Khadak Singh also did recognize this right to privacy as a part of the Article 21 of the Constitution. And then Govind versus Madhya Pradesh case came, and after that, what we saw, it was in 2017, Justice K.S. Puttaswamy versus Union of India, where a unanimous court of 9 judges declared for the first time that right to privacy is a fundamental right under Article 21 of the Constitution. Prior to that, we're also having 1995 Auto Shankar case, Rajgopal versus state of Tamil Nadu, where also the court had gone to an extent to say this right to privacy as a part of Article 21. So it was a larger bench judgment. It was a unanimous judgment of 2017, where the court said that right to privacy is a part of right to life and personal liberty. So you are all students of law here, and you must be knowing that prior to this 2017 K.S. Puttaswamy case, the court was interpreting Article 21, whether it's a right under right to life or under right to personal liberty. So some of the extensions made under the right to life, some of the extensions were made under right to personal liberty. And this is the first case where you find that the court said this is the life and personal liberty both. So right to privacy is having put on some we can say greater on the greater side has been given by the Supreme Court, so that this right to privacy is now a part of right to life and personal liberty both. And from there you see that this was a case related to the Aadhaar, and this was the case related to many of the data that was being given by the person concerned and how that data is being used. That was the issue, and the court said that this is the right to privacy, and for that the recommendations were also given for making the law. The law has not yet come to protect the data. However, there are certain points which I would like to discuss with you regarding this DPDP bill, Digital Person Data Protection Bill of 2022, though it is not passed, and I am not seeing any possibility in near future, because once it has to be put in the budget session, it was not brought before the budget session of the Lok Sabha. And when again it will be put before the Lok Sabha, it is also not clear. So I suppose that it is going to have the same weight as of the earlier 3 bills of the data protection. One that was made by under the chairmanship of the Committee of Justice B.N. Shri Krishna also. So we find that this data protection, digital person data protection bill is again not going to be going to see the daylight because like of the earlier bill. But the point here is that why do we need this Data Protection Act? Because of our privacy only, or for something else? This point was discussed because since 2015 we have entered in the digital India. Because the present regime at the center that speaks about the digital India, and because of that digital India, we know that more than 75 crore Indians are using their smartphones and 130 crore Aadhaar. So you see that when I'm talking about that more than 130 crore are using the smartphones, then this smartphone is your DNA. This is having more than 14 sensors on every time. Today, when I have given my current location to the persons who are coming to escort me from my residence to this place, and at my place, there is one Google Home also that was always on. So I was taking this, I have given this current location, and all of a sudden, my Google Home speaks, your vehicle arrived at your gate. That was And then I thought that everything that we are doing, that is being recorded. When I was coming to this venue through that lift, then I saw one of the sticker which says that your audio video recording is under surveillance. So this sensor of this mobile phone which we are using, this is always open, and we are all using different types of the apps. And particularly, if you see after the COVID period or during COVID period, many of us are now used to have the benefit of different apps online. We are the great purchaser of all these things. E-commerce has been developed, education is developed, traveling, communication with steps of the technologies and apps we are using because of this technological development. So in this digital India or digital era where we are having this 4G and we are also rushing for this 5G, it is the second largest population after breaking through this US. US was the second largest country, which was the largest user of the technology. Now India is the second largest in the world. And this has happened only during this COVID period, that many of us have started using different types of the technologies and online things to save our time, to have the facilities, and to make our life more and more easy. So largest sources in India, that is the commercially useful data, and that is also very important for the purpose of the protection also. Therefore, what we see is that we are having this rapid advancement in the technology and data privacy. And for that, this DPDP is important in the sense that it is giving some of the important definitions like data fiduciary, data principal, data processor, and processing. So when we use any application online, then we must know, as Trivedi Singh ji also spoke about that, knowing is something, but knowledge of the things is one thing, while doing that thing is different. We may have the knowledge of the things that by doing this may be violating our right, or this is a wrong thing. This is only our knowledge. But if we do that thing with that knowledge, then we can save ourselves, we can secure ourselves, we can take our fundamental right to privacy also. So we have to be very, very, eager to know that what are those things which we must know, we must avoid, so that it may not interfere in our privacy. For example, when this WhatsApp case was brought before the Supreme Court, and before that there was some rulings that encryption of the data that could not be there. So many of the users, they were asked to move to another app, that is Signal. But very few have used that Signal app. However, the data is there. So do you know that data which is available there on Signal, that may be erased from their processing or not? So knowledge is one thing and doing is a different thing. We are having many of the apps on our mobile phone, whether it is related to Amazon, Myntra, Blinkit, Instamart, whatever. So if we are using that app, that is okay. But if we are not using that app, we should erase that data from that data fiduciary. Because if we are having our data with that fiduciary accompanying, then it would be misused, sometimes legally, sometimes illegally also. Because we are living in a country which is welfare and e-governance is there. The government is also in India, because under this act, you see, the government is said to be the biggest data fiduciary, and that is also having our various records and information. So that can also be used and misused accordingly, because once we talk about the state largest in the shape of the healthcare services, in the case of the public distribution services or other types of the reliefs, then it can be used properly. But otherwise, the data remains with the data fiduciary, that is the government on the one hand and various companies on the other hand. So it is up to us that what data should remain there with the fiduciary, we have to go and we have to apply for that. Our data should be erased. So one of the important feature of this data protection digital person bill is that the every data principal that is the user or the consumer who are putting or filing the data on the various platforms. So this is our right, digital right, that we can ask for data erasure. At the same time, we are also having the right that our data may be corrupted. So these two rights have been given by the DPDP bill, but the persons who have seen the earlier bills of 18, 19 and 21, then there was also one of the important rights available to the digital data principal, that was right to be forgotten. That is not the part of this bill, and for which it is being criticized also. Then data portability is also one of the right which was there in the earlier bills, which is not available in this act, in this bill of 2022. So again, it is being criticized for that. However, one important factor from the point of view from a human rights angle is that in this bill of 2022, you see that if a person who is below 18 years of age then can nominate the guardian for that also. So in that way, the autonomy of that child, which is given under the Convention of the Rights of Children, that is also coming under the contrast with this data DPDP bill of 2022. So these are few points which needs discussion, and in that way, when our information data is with the data fiduciary, and in this bill, it is with the central government in maximum cases, that can be sent to the other countries also with the permission of that. However, one mechanism is also provided in this bill, that is the data protection board. And if there is any complaint, then that data protection board can take action and can give some remedy. But penalties which are there that are very hefty, you see, and 250 crores and all these penalties have been there. So the point here is that though we are having this bill and this is open for discussion, many of the recommendations have been sent by various users, but still the question that is here for as a challenge, as an issue, which is there, that remains of the digital sovereignty. Now, data is of the data principal. Data is with the data fiduciary. Data fiduciary has all the powers to use that data legally, illegally, for any purpose. The rights are very less in the bill. Then the question is, who is sovereign for that data? Who is the digital sovereign? Because state on the one hand and the individual on the other hand. So how to match the level of the state on the one hand, data fiduciary, that is the government, or the big companies, and on the other hand, the private individual like me and you. So this is a challenge on which I suppose that the seminar delegates, they will discuss and deliberate on that. And then the only thing is that if you are having a knowledge, at the same time, you must also be the courage of doing that thing. You must also have the courage to report if there is any violation, because many a times we feel that it happens. So what to do, where to go? So first of all, before allowing any of the app, before installing any of the app, you just don't say yes for all the things. Because if it is an app like Myntra, you are downloading on your mobile phone, and it is asking for so many things, and you have to allow those things. And it is saying that the Myntra wants the entry in your photo gallery. Whether you should allow or not. Is it required that the Myntra needs your photo gallery also? So that is the point, that whenever you are using any of the app, you must clearly know about the things, you must read the things, only then you could pick the yes or no, allow or not to allow the things. So if there is something like Signal or WhatsApp, what is required, you can allow for that, and don't allow all the things which they are requiring. That would save your right to privacy, that would save yourself in this digital world. And this is up to us only, because cyber crime is always there. As told, there are so many forms, from starting from the morphing to the extortion, phishing is moving, so many things are there. And the only thing is that whoever may be a cyber criminal always leaves the digital footprint there. And that is the point where from one can investigate and can see that the person, they are the criminals, and that is how we are safe. But instead of leaving these things to the cyber police, we can also make ourselves that way, and we can police ourselves to make assure that our rights are safe and secure. So with these words, I would like to thank once again the organizer for giving me the opportunity. I have to say that myself.
Thank you so much, ma'am, for this insightful and enlightening session. The fragrance of flowers spread only in the direction of the wind, but the goodness of a person spreads in all directions. I'm profoundly delighted to take an opportunity to welcome the chief guest for today's inaugural function of National Seminar, Professor Dr. Sudhir K. Bhatnagar, Honorable Vice Chancellor, Dr. Ram Manohar Lohia, National University. Professor Bhatnagar has a long teaching and administrative experience. He has completed his LLM from Kurukshetra University and PhD in law from Rohtak University, Haryana. He has worked in various capacities in Babasaheb Bhimrao Ambedkar University, Lucknow. Some of the major positions held were Dean Law and Acting Vice Chancellor of Baba Bhimrao Ambedkar University in 2001 and 2007. Professor Bhatnagar has served almost for 4 decades as law teacher in university department. He has also been member of the first academic council of the National University, Bangalore. He has been nominated by the Chief Justice of India as a member of the Executive Council of the Indian Law Institute. Based on his long teaching experience and research experience, he has contributed in many reputed institutions of national repute, like members of the academic bodies of Himachal National University, Assam National University, member of the academic bodies of University of Delhi, Bhopal, Nainital Allahabad University, and Karnavati University, Gujarat. Professor Bhatnagar has published around 3 dozen papers in reputed journals and edited books. He has also been the part of editorial and advisory boards of the reputed law journals. Apart from this, he has invited by the All India Radio to deliver several talks on legal and other issues. His special interests include legal aid and literacy programs. May I have the pleasure of inviting our chief guest, Professor Dr. Sudhir K. Bhatnagar, Honorable Vice Chancellor, National University, to take the floor and enlighten.
Thank you, Anupri. Good morning to all and everyone. My former colleague, Professor P.T. Saxena, Director, PG Legal Studies Center, and ex-HOD, ex-Dean Law, Professor Asad Malik, the Pro-Vice Chancellor, Wing Commander Tiwari Saab, Professor J.P. Yadavji, Rajiv, Shashya, delegates and dear students. The theme of this seminar is right to privacy and data protection. And on data protection, Mr. Triveni Singh has spoken. And on other aspects of this seminar, Professor P.T. Saxena has spoken. Nothing is left for me, but even then I have to say something. So I may bank upon my understanding of right to privacy, which I gather from legal theory. Aristotle, who was a political philosopher and has made inroads in legal philosophy also,
made a clear distinction between two lives of the human being. One is political life, another is domestic. And at that point of time, privacy was not a concern at all. So he didn't say much about privacy. But he made it very clear that we have two lives and there is a boundary wall between the two, political life and domestic life. And then as pointed out by Professor P.T. Saxena, Edward Hawke made it very clear that home is the castle of the owner, meaning thereby that there cannot be any arbitrary interference in his privacy, family, home, or even to take cue from this UDHR, correspondence, reputation, and honor. Even then, right to privacy was not recognized by British courts as a fundamental right. But there are traces of right to privacy when we come to law of community living or neighbors law, which we call law of torts. How to live together in a community. So if my home is my castle, your home is your castle. And if there is a dispute, that was to be adjudicated. Because I am claiming my privacy, you are claiming your privacy. I am saying कि मैंने पौधा उगाया है, you are saying कि आपका फल हमारी तरफ. So that means that it has to be resolved how we can live as good neighbors. So law of torts developed and it has traces of right to privacy, but it was person versus person, neighbor versus neighbor. And the state had no problem in developing this law of privacy, though it was developed by the judges. Here state was not in focus. So law of torts could develop very easily by the judges, knowing fully well that the judges were also a part of the sovereign. You know, whenever you read law of torts, king's bench, queen's bench. So they were sitting on the bench provided by the king or queen. So they were acting on behalf of the sovereign, and sovereign was not bothered about it, that if all privacy is developing between two neighbors, then it didn't bother them. Now we come to the making of the American Constitution. Now USA Constitution, that is, when it was being made, it was made under the influence of the theory of social contract given by John Locke. Now, first of all, we can trace it to Grotius or to Hobbes also. Hobbes' Leviathan was very powerful, and it could not recognize even the rights, what to talk about right to privacy. According to that social contract theory, when you come in the society, you come in the community living, then you give away all the rights to the sovereign. Sovereign will protect you from violence, from other invaders. So there is no need of having rights or right to privacy was not an issue. But that was disputed by John Locke, because Hobbes gave a charming explanation for the social contract theory, that the life of a human being in jungles was very brutish, solitary, not peaceful. All were at war at all the points of time. But John Locke didn't agree with that. He said that before coming to community, the life was peaceful and we were living in harmony. We had less desires. So this theory of John Locke, of social contract theory, that there is a kind of a trust between the sovereign and the subjects, that is to be reflected in the constitution or in any kind of rule of governance. That is why do we come in the society? Why we make society not only to protect ourselves from the outer invasions, but to enjoy the life itself. We cannot barter away our happiness. That is why American Constitution starts with the words that why we have made this United States of America of 13 states. One of them, the objectives of making of USA was pursuit of happiness. That if we come together, we want to remain peaceful and we want to enjoy the happiness. But the question arises whether right to privacy was a concern or not. Initially, when the American Constitution came, it didn't have any rights. Then later on, Bill of Rights came. And if we go through Bill of Rights of United States of American Constitution, we find that there is Fourth Amendment. Now, Fourth Amendment says that there will be no search and seizure unless and until it is authorized by law with reasonable reasons. Search and seizure of whom? Search and seizure of person and home. So why it was accepted? Because before coming to USA, making this USA, in all these 13 states, they were free. So they were having some kind of distrust against a new government that it can involve in going into for search and seizures. So they put it in the Constitution that there will be no search and seizure. So search and seizure is an aspect of recognition, you can say, of right to privacy. And then again, very interesting right is there. You know, that right is creating problems. Right to bear arms, that you can have arms, legally speaking. And more often you hear stories where a young chap will go around the school, or any pagla will go and shoot many persons. But what is the basic idea? What is the history of having right to bear arms, search and seizure? All of them were part and parcel of right to privacy. And why it is so? Pursuit of happiness. Then we come to the Indian Constitution, and that has been explained by Professor P.T. Saxena through cases. Now, Khadak Singh case. In Khadak Singh case, the Supreme Court was not in a, and before that, Sharma case, the Supreme Court was not interested in accepting right to privacy for the simple reason because we were forming a new republic and we were tormented by partition and other rights also. In that situation, and moreover, we believe that our government at that point of time could protect everything. So that's why the Supreme Court or the government also, they were not in favor of having right to privacy. Despite this, in Khadak Singh case, it was accepted that right to sleep is a right. Domiciliary visits maybe could be held unconstitutional. Then why do you go and make, because you are a suspect also. So why are you having surveillance of that time? So, but out of that, there is some ray of hope that the Supreme Court accepted that the right to sleep is part of right to life. If you don't sleep, then how can you enjoy life? And if you can recall in the same case, the Supreme Court has said that right to life means not merely animal existence. Even animal also would need the right to sleep. But even then, this was accepted. Then came many other cases. But in the meantime, what happened in 1965, in the Supreme Court of the United States of America, a case came which was regarding the ban on contraceptives. A state had passed a law which banned the use or so to say sale of contraceptives. Now, in that particular case, right to privacy was recognized, and the government of the USA or of the state was also not bothered about it. Now, this idea of privacy became very important and crucial when the citizens started demanding this privacy against the government. So if it is person to person, no issue. For example, 377, that was struck down. So if 377 is struck down, it doesn't make any difference for government. But that is the recognition of right to privacy. If in Sabrimala goes off the track, if women are allowed, then the government is not bothered. When this particular scenario developed as a crisis between the citizen and the state, then there were difficulties. And when Aadhaar was being, thought about, and then, Aadhaar started. So that case, Puttaswamy case, was basically on Aadhaar. That is what the Dr. P.T. Saxena referred to as digital footprint. That the state will gather the data. Now, data with the state. So we cannot believe the state. We don't have faith in the state. The same thing which happened in the United States of America about 200 years ago, that we can't believe this state. We will not allow the state to have certain seizure. We will bear the arms. We can defend our territory like that. But now the situation had arisen here also. And before that, this the government was not bothered. What happened in this Sharma case and other cases also. Now, in Puttaswamy case, this is recognized. After that, because it was very much related to data protection also. Now, 4 avatars of data protection law, bills have come. Now, as Professor P.T. Saxena made a prophecy here, I never thought about it. She said that it may also see not the light of the day soon. Why it is so? Why so much? Inconvenience, and why the government is so uncomfortable that within the span of 4 years, they have brought 4 bills, and they can do it because for the last 30 years we are hearing that 1/3 reservation for women will be in Lok Sabha and Rajya Sabha, and it has not come. So there are certain issues which are at the back of the mind of the state, if the state has a mind. That is bothering them. Now, the previous avatar was, bulkier. This avatar is slimmer, about 1/3. But then the question arises that data fiduciary, who will be that entity, the state, we can't believe. Facebook, we can't believe. But then you say that we have to give our data because the benefits are being linked with data. We are moving in the digital India direction. So the best thing is what I think Professor P.T. Saxena suggested. I am quoting her again. Bhaiya, bacha lo apne. Prevention is better than cure. Mr. Triveni Singh spoke about cure, and Professor P.T. Saxena spoke about prevention. So prevent yourself. But in digital India, that prevention is not possible. Because if you have to have digital economy, digital health, and what not, because she was telling that a chip, I think Triveni Singh was speaking about it. You? Okay. So you were speaking about this, that a chip can be placed here. Mere dimag mein aaya, if my brain is hacked, it is possible. So I will lose my identity. It's not personal data, but it is related to identity. But if it comes in my brain, and if it is there, then my brain can be hacked. There are many possibilities. So, what are the concerns of this new data, personal data bill? One of the things which I could understand, because Triveni Singh ji understands more than what I can understand. I also behave like a common citizen. I am not an online magazine. Okay, my daughter, my son, so they do that. But that's a different thing. One important feature of this data bill is that they have decoupled, de-linked this localization and national security. Because this is, full of threats also, there is no doubt about that. But if you are moving toward the direction of the digital economy, you will have to decouple these two things. And when these two things are decoupled, there may be many threats also. Because national interest would include national security, national order, integrity, unity, public order. Why not join? And then there is another question that if Article 352 is invoked, we know 21 cannot be suspended. Then right to privacy is part of Article 21. So whether data protection law, if it is there, what would happen to that? If we have already given, privacy rights and many liberties, now as Professor P.T. Saxena pointed out, now it is connected with your life and personal liberty both. That confusion is known. What would happen to that? Must be some thinking going on in the official circuits also. There are other points also, big data judiciary, significant data judiciary. They are bigger than the governments. They pay the political parties. So anything can be done. But I believe that this particular seminar is concerned with personal data, because right to privacy and data protection. So what we can do, first of all, we can follow the advice of Triveni Singh, and you can take his mobile number from Professor J.P. Yadav. And then I think I am comfortable with the advice of Professor P.T. Saxena. उसमें जाओ. So आपको, you will have to go. I don't say because you are in early 20s, and I am also in these. So there is a difference. But anyway, I think this debate will go on, even if the act is made. Because what is privacy? Privacy is a moral kind of a thing. It cannot be defined so easily. If you could not define life, you could not define liberty, you cannot define privacy. So there will be cases and cases. So this debate will go on. There will be multiple webinars and seminars. It's a debate like coffee or toffee, coffee or toffee. So it will go on. But the thing is that whenever you hold this kind of seminar and you, have the practical experience of the police cops, or rather the cyber cops, then we feel enlightened, we feel frightened, we feel satisfied also. At least for me, if you have given me this opportunity, this purpose has been served. Thank you very much.
Thank you so much, sir. As rightly said by sir, when life and liberty cannot be defined, so definitely the privacy also cannot be. Sir, it was an insightful and knowledgeable address for our audience, and definitely our audience has much hard value to take away from the address. Thank you so much. Next is the appreciation portion that has to be conducted. That is, as rightly said by Voltaire, appreciation is a wonderful thing. It makes what is excellent in others belong to us as well. As a token of gratitude and honor, I would now request Wing Commander Dr. Anil Kumar Tiwari, sir, Deputy Vice Chancellor, Amity University, Lucknow, to present the memento to the Chief Guest of the inaugural function, Professor Dr. Sudhir K. Bhatnagar, Honorable Vice Chancellor, Dr. Ramanohar Lohia National University. Thank you, sir. I would now request Dr. Rajiv Kumar Singh, convener of the event, Amity Law School, to present memento to our keynote speaker, Professor Dr. Preeti Saxena Ma'am, Director, Center of Postgraduate Legal Studies, former head in the School of Legal Studies, Baba Saheb Bhimrao Ambedkar University, Lucknow, as a token of respect and appreciation. As Ralph Emerson believed that the reward of a thing well done is having done it. However, we would be falling short of a duty if we do not recognize a thing well done and encourage it. May I now request Dr. Rajiv Singh, sir, faculty convener of the national seminar, to deliver the vote of thanks.
Thank you very much, Dr. Priya Madam. Good afternoon, everyone. Respected Pattern-in-Chief and Council President of MT Educational Group, Honorable Dr. Ashok K. Chauhan, sir, Co-Pattern-in-Chief and Chairman MT University Uttar Pradesh, Lucknow campus, Dr. Asim Chauhan, sir, Patron Professor Dr. Balwinder Shukla, Madam, Vice Chancellor, MT University Uttar Pradesh, Wing Commander Dr. Anil Kumar Tiwari, sir, Deputy Pro Vice Chancellor, MT University Uttar Pradesh, Lucknow campus, and our most valued invited guests, ladies and gentlemen. An event like this cannot happen overnight. Actually, the wheels start rolling a week's ago. So it requires planning and bird's eye view for all the details, and we have been fortunate enough to be guided by our revered director, MT Loy School, and backed by a very motivated team of MT Loy School, Lucknow, who know their job and they are very much result oriented. I feel honored and privileged today to get an opportunity to propose a vote of thanks before this August gathering. It is indeed a very memorable day for all of us when the eminent dignitaries are and were with us in this inaugural session of this two-day national seminar on right to privacy and data protection in digital era issues and challenges. I, Dr. Rajiv Kumar Singh from MT High School, Lucknow, on behalf of the Pattern-in-Chief, Co-Pattern-in-Chief, Madam Vice Chancellor, in her absentia, would like to express my deep sense of gratitude to convey my deep regards and hearty thanks to our Chief Guest, Professor Dr. Subir K. Bhatnagar, sir, Honorable Vice Chancellor Dr. Ram Manohar Lohia, University, Lucknow, for his esteemed project. Sir, you are always truly an inspiring source of encouragement, which keeps us motivating the legal fraternity to update in their knowledge of law and discuss on such contemporary issues. Thank you so much, sir, for enlightening us from your deliberation. I think, sir, ने जैसा भी कहा, मैं उसमें सिर्फ एक चीज जोड़ना चाहता हूँ, मैं बधाई देना चाहता हूँ डायरेक्टर एमटी लाइव स्कूल सर को। एक्चुअली हमारी कोशिश थी कि आज हम शस्त्र और शास्त्र दोनों को एक साथ इकट्ठा कर पाए। दोनों में एक अंतर डंडी का है, वो डिफरेंस चले गए। अदरवाइज हमारी कोशिश थी कि थियरी और प्रैक्टिस दोनों साथ में चले, तो आपको बधाई। I express my sincere and profound thanks to our guest of honor, Dr. Trivedi, sir. We are greatly encouraged by his gracious presence and immensely benefited by inspiring and thought-provoking ideas. It is a matter of immense pride for me to convey gratitude and sincere regards and very hearty thanks to the keynote speaker of this two-day national seminar, Professor Dr. Preeti Saxena, Madam. I am sure that all the participants have taken note of your theoretical as well as practical suggestions and will involve in serious discussion in this two-day national seminar and after the seminar within their organizations, the action to be initiated at their level. I also express my sincere gratitude to our Deputy Pro Vice Chancellor, MT University Uttar Pradesh Lucknow campus, Wing Commander Dr. Anil Kumar sir, for providing continuous encouragement and support through his inspiring leadership. Sir is always available for us whenever we request him for any sort of help. Thank you very much, sir. I am very grateful to Professor Dr. Jayaprakash Yadav, sir, chairman of this two-day national seminar and director MT Law School, Lucknow, for his support in conducting this national seminar as well as foundation of this national seminar. I want to express my hearty gratitude to my joint faculty convener, Dr. Sasya Mishra, Madam, and the entire core team of this national seminar, namely Dr. Amresh Kumar Srivastava, Dr. Reshma Ume, Dr. Taru Mishra, Dr. Anuj Kumar Sharma, Dr. Priyanka Srivastava, Dr. Abhishek Anand, and Ms. Sarita Yadav. I want to express my hearty thanks to all my faculty members involved in the technical sessions. Dr. Kumkum Srivastava, Ms. Malvika Bose, Ms. Priyanka Srivastava, Ms. Aishwarya Pandey, Dr. Amreen Kumar Srivastava, Ms. Aradhana Yadav, Ms. Josna Singh, and all the National Seminar Committee members. My heartfelt thanks to all the ALSM faculty fraternity for their support in their national seminar. I want to thank my dear students, co-convener Ms. Jasmine Suri, Varsha Ritparna Das, Yash Krishna Pandey, and student organizing secretary Siraj as well. My special words of thanks to all the non-teaching members of ASL, concerned office bearers of MT University Uttar Pradesh Lucknow campus, Mr. Sodi ji and Puneet ji from IT section of MT University Uttar Pradesh and Noida, and admin and security departments of their all helps and cooperation that they have provided for us in the successful conduction of this national seminar. A big thanks to all the distinguished participants who have come from distant places to attend this seminar, making this successful by their vibrant suggestions. This reflects their commitment towards their profession. We all hope that this seminar will provide a platform to share knowledge and expertise critical review of the issues leading to define goal of our profession. My sincere thanks to all the media friends for their presence and giving excellent coverage for this. I'm hoping the excellent coverage for this national seminar. Finally, I thank all the young and energetic, our UG, PG students, research scholars. They have participated and given their support, all the support for this national seminar. And at the end, I once again thank you all for your distinguished assemblies in this moot court hall of MT High School, Lucknow, Uttar Pradesh. And nowadays, in the last, we talk through computers, we write through computers, we work through computers, and we even govern through computers. So I will rest my vote of thanks with a quote of Mr. Carrie Snow. He has said that technology is a pure thing. It brings you great gifts with one hand, and it stabs you in back with the other. Thank you very much.
I'm signing out. Thank you, sir.
Now I will request everyone present in the hall to please stand up for the national anthem. I request everyone to assemble for the group photograph.
क्या सेवा करें चाय में पियोगे अभी तक चलते
Considering
end of the inaugural function, participants of the technical session are requested to be present after 15 minutes after their team in 101, 106, room number 106, it is there for the participants. Everyone can go and have the tea, and after 15 minutes, join here for the technical session 1.
University of Lucknow. We have our faculty and the participants who have come from all across the country to be a part of this academic discussions. Now, I would like to call upon stage our esteemed faculty, Shobha Ma'am, to greet and welcome our guest of the session. Warm greetings to one and all present here. It gives me immense pleasure to introduce our respected guests for the technical section 1. Today we have with us Dr. P.T. Mishra Madam, Dean School of Legal Studies, former Head, Human Rights Department, Babasaheb Bhimrao Ambedkar University, Lucknow. Now we request Rajiv sir to please give the sampling as a token of respect to ma'am. Please give a hand. Ma'am has completed her LLB, LLM, and her LLD from University of Lucknow. Her professional experience includes 22 years of teaching plus and research experience. Area of research in women laws, criminal justice, criminology, human rights, IPRs, and the wonderful papers that she has written in various international areas, including security, right to health, protection of women, secularism, good governance, and so many others in come. She is a part of other bodies, etc. Ma'am, it gives me immense pleasure to welcome you in the seminar. The next person and our esteemed guest for the session is Dr. Alok Kumar Yadav, sir. He is Associate Professor at Faculty of Law, University of Lucknow. And I request Shasha Madam to please read sir with the sampling. Please a round of applause. Sir has a LLB degree from Gorakhpur University, LLM from Ram Manohar Lohiya University. His teaching experience is 7 years plus. Area of interest include commercial law, administrative law, IPR, etc. He's a member of various reputed boards and published and part of various national and international seminars. His publications are also in a vibrant way, which includes trade secret protection, legal education, food security, social justice, cyber talk, etc. It gives me immense pleasure to welcome you for this event, sir. Now, with the welcoming of the guest, we will begin with the technical session 1. So I will request. And here forward, she will be calling out the names. The details has already been shared with the guests. So please mark them accordingly.
वही Zoom पे शेयर करनी होगी उस पे इसके बोलते रहेंगे चेंज कर
As he said, it takes as much energy to start as it takes to end. In this note, we commence the session with high zeal and enthusiasm. The topic is right to privacy, a view from Constitution.
For the first time, the constitution validity of Aadhaar system was challenged before the Supreme. In the renowned case of Justice K.S. Puttaswamy versus Union of India. While the judgment of this case overruled the original judgment of P.M. Sharma and Kharak Singh case. Good afternoon, one and all present here. My name is Samarth Gupta, along with Raghav Nishad. It's an honor for me to speak before this honorable audience. I will serve the constitution perspective of the validity of the right to privacy. So let's start and find out the answer of the question mark that why the judgment of were overruled. The Supreme Court for the first time recognized the right to privacy, which is the implicit of the Constitution under Article 21 in Puttaswamy case. The court held that the right to privacy is an integral part of right to life and personal liberty as guaranteed under Article 21 of the Constitution. Now, let's set aside this case and talk into a layman language. If someone makes an arbitrary interference in your private life, family, and on your reputation, then it is against your dignity and confidentiality. It is the duty of the state to take care of the bodily integrity and the personal autonomy. So Indians do have right to privacy and they enjoy it under Article 21 of the Constitution. And in this regard, Supreme Court had that to protect the validity of the fundamental right to privacy. Isn't it any requirement to declare the right the same is protected under Article 14, 19, and 21? Now, why the need to protect is required? For this, I would like to call my co-author, Raghav. Over to you.
Thank you so much. India is rapidly becoming a digital economy. We are a nation of billion cell phones, and yet we don't have any laws for data protection and privacy. So we need a robust data protection mechanism. The state is obliged to put this mechanism in this digital age. So our research paper is all about how the Indian Constitution look at privacy. We are a little bit short time. So we did not bind all the aspects of our research paper. Now I will conclude of our research paper my presentation by saying that right to privacy is a requisite of a right to life and personal liberty, the Article 21 of Indian Constitution. As every day is advancing, this right is becoming more and more essential with all our lives being exposed to the media through social networking. The protection is given to everyone and no one includes the right to privacy of the individual. But at last, it should be the duty of every individual to protect their data as much as they can, because every right delivers a duty along with itself, as it is taught by our Constitution faculty and Assistant Professor Dr. Rajiv Kumar Singh sir. Now, a heartfelt thank you and bucket of love to all of you for hearing us very consistently. Thank you.
Next participants are Kaiful Vara and Avril Singh, and their topic is Central Information Commission Report, Right to Privacy.
Good afternoon, one and all present here. My name is Aviral Singh from DLLB Honors, along with Kaiful Vara. So here we start. Privacy is not something that I merely had titled, so it is an absolute prerequisite by Marilyn Brando. The right to privacy is an element in various legal traditions to restrain governmental and private action that threaten the privacy of individuals. There is now question as whether the Right to Privacy Act can coexist with current capabilities of intelligence agencies to access and analyze virtually every details of individual's life. A major question is that whether or not the right to privacy need to be forfeited as part of the social contract to bolster defense against support terrorist threats. Privacy uses theory of natural rights and generally respond to new information and communication technologies. Right to privacy and telephone tapping, allegation of political opponents and even colleagues being under surveillance have been endemic in our country under all design over the last decade. It has been held to be serious inroad into the right to privacy, a fact of the right to personal liberty. Section 5, Clause 2 of Indian Telegraph Act of 1885 empowers the central government or the state government or any specially authorized officer to intercept message if satisfied that it is necessary or expedient. So do it is in the trust of sovereignty and integrity of Indian security of the state-friendly relation with foreign state, public order, and preventing incitement to the commission of an offense. Development of privacy law in India. The purpose data protection framework is through the ratio of the judgment of the Supreme Court of India in Puthuswamy case. The Supreme Court held that the right to privacy is fundamental right securing individual liberty in the constitution. Privacy itself to have negative aspect that the right to be let alone. The positive aspect is that the right to the self-development. Privacy is too can be restricted in well-defined circumstances. Number one, there is a legitimate state interest in restricting the right. Second, the restriction is necessary to achieve the interest. Third, the restriction by law. Further topic will be concluded by Kapil Vora.
This is Kapil Vora from BLLB Honors. So there is constitutional privacy rights. First, the First Amendment provides the freedom to choose any kind of religious belief and to keep the choice private. Second, the Third Amendment protects the zone of privacy in home. Third, the Fourth Amendment protects the right to privacy against unreasonable searches and seizures by the government. Fourth, the Fifth Amendment provides for the right against self-incrimination, which justifies the protection of private information. Fifth, the Sixth Amendment, interpreted as justifying a board reading of the Bill of Rights, protects your fundamental rights to privacy in ways not provided in the first 8 amendments. What is datafication? We begin by explaining how datafication forms a specific context for concepts of privacy and their articulation. Datafication is a complex process that is often associated with digital technologies and big data infrastructure. So there's a plethora of cases on privacy, but none of the cases were in favor of considering privacy as a fundamental right only after the passing of a landmark case, that is case Puthuswamy versus Union of India in 2017. Right to privacy given due recognition. The right to privacy is not only conceded nationally, but also internationally under various conventions. Right to privacy being a dynamic concept is incorporated under provisions of various legislations and also embraces various aspects. Studying privacy in depth, we shall come to know about the pros and cons of this right to privacy with certain reasonable restrictions, where the transgression of this right is not considered an offense. In this article, we will be discussing various dimensions regarding the right to privacy nationally and internationally, reasonable restrictions, various case laws, and the latest development, which also include the latest bill regarding the right to privacy. So the Khaled Singh case was a state of 1962. The right to privacy was invoked in this case to challenge the surveillance of an accused by the police. Khaled Singh was arrested for Dakaiti but was released. Due to lack of evidence, the UP police subsequently brought him under surveillance, which was allowed under Chapter 20 of UP police regulations. Khaled Singh then challenged the constitutional validity of Chapter 20 and power as it conferred upon police officials, as it violated his fundamental rights under Article 19, Subclause 1, Subclause D, and Article 21, right to liberty. The sixth judgment held that the domicile visits at night was unconstitutional, but upheld the rights of the regulation. More importantly, the bench held that the right of privacy is not a guaranteed right under the Constitution. Thank you so much. It is a reminder to all the participants that we cannot exceed 2 to 3 minutes time. The next participants are Harshvardhan Singh and Pragya Singh, and the topic is right to privacy and data protection in digital era. Is an inherent human right and a requirement for maintaining the human condition with dignity and respect. Good afternoon, everyone. Today, I, Pragya Singh, along with my co-author, Harshvardhan Singh, will present a research paper. My topic is right to privacy and data protection in digital era. We live in an era when we no longer have to stand in dense queues in front of banks for banking services, and after putting on an online order, we can get any item at your doorstep. That is the information technology boom. With the evolution of internet and its extension in accessibility, we are seeing a new world where communication, accessibility, sharing of information, and transparency are better. But as it is said, there will be some disadvantages for everyone. As technology is increasingly developing, so is a rise in its misuse, which is largely inevitable. The concept of privacy is not alien to Indian society. The difference between public and private has existed since the advent of the Indian civilization. Privacy is the right to be left alone or free from character violence or misuses. The right to privacy is the right to be free of unwarranted advertising, to live without unwarranted public interference. Article 21 of the Indian Constitution offers that no person shall be deprived of life, personal liberty, except according to the procedure established by law. The Supreme Court ruled on 24th August 2017 that right to privacy is a fundamental right guaranteed by Part 3 of the Indian Constitution. The new regulations will now be tested on the same parameters. Related cases: in the case of Kharak Singh versus State of Punjab, the court regarded whether it would be an abuse of the right guaranteed under Article 21 to monitor an accused home's visit at night, thus raising the question of whether the Article 21 included the right to privacy. The court ruled that in reality, such monitoring was contrary to Article 21. The majority judges held that Article 21 did not expressly provide for provision of privacy, and therefore right to privacy could not be interpreted as fundamental right. In the case of K.S. Puttaswamy versus Union of India, it was held that privacy concerns in this day and age of technology can arise from both the state as well as non-state entities. And as such, a claim of violation of privacy lies against both of them. The judgment in this landmark case was finally pronounced by a 9-judge bench of Supreme Court on 24 August 2017, upholding the fundamental right to privacy emanating from Article 21. The right to privacy is not clear or explicit. It has been subject to judicial interpretation in the Constitution of India. The judicial interpretation of the fundamental rights brings this right to privacy within the ambit of fundamental right. Constitution of India grants privacy of data by recognizing the right to privacy of data by recognizing the right of privacy. Right of privacy has been as an intrinsic part under Article 21 by Honorable Supreme Court, which protects the private data as a private property of citizen. Network surveillance is the monitoring of the computer activity in a network. It is usually done covertly by organizations, governments, or individuals to monitor illegal activities. The General Data Protection Regulations require companies to clearly ask for consent. When collecting consumer data. 2 international conventions are of particular importance in terms of privacy rights. These include UDHR, Universal Declaration of Human Rights, and International Covenant on Civil and Political Rights. Article 21 of Universal Declaration of Human Rights and Article 17 of International Covenant on Civil and Political Rights provided that no one shall be subjected to arbitrary or unlawful interference with his or her privacy, home, family, or correspondence, to unlawful attacks on his or her human. Now Harshvardhan Singh shall continue.
Cyber fraud and its impact on Indian economy. This century has brought to reality the idea of global village, where digital technology has interconnected and remains the world economies, cultures, and population. India is the second largest internet population user in the world. With every boon paid, the recent incidents of hacking into various popular websites of Yahoo, CNN, Sony, the CBI, and the Indian Army raised the very pertinent issue of online data privacy. In the 1970s to present, we saw cybercrimes taking different trajectories like impersonation, frauds, identifying thefts, and various virus attacks. Revenge pornography. The combination of easy access to the internet and camera enabled smartphones and widespread participation in online social networks has provided a ready platform for performing sexual violence, abuse, and harassment. Revenge pornography has been one of the form of online pornography that is usually created with the consent of victims and then is distributed without the consent of individuals. Revenge pornography has been classified both as sexual offense, as an offense of privacy. The right to privacy includes with its ambit the protection of autonomy and well-being of the individual and the right of self-realization of that individual. Ransomware. It is a malware designed to deny a user or organization access to files of their own system. On November 2022, a ransomware attack on the servers of All India Institute of Medical Sciences AIIMS in Delhi wreaked havoc on the system, and all their processes had to go manual. Think about it. A hospital or any medical institution has a vast personality, identifiable information on people more sensitive than any other kind of data that may get stored in a ransomware incident. The lost entity under the attack is often not tangible. What is more worrying is that there is a little no liability. Even in the case of attack as massive in this in United States, the Health Probability and Accountability Act has ensured that right to privacy is to be maintained. Phishing and other cybercrimes. Phishing is a type of social engineering attacks often used to steal user data, including login credentials, credit card numbers. It occurs when attackers masquerading as trusted entity groups into a victim into a opening an email, instant message, or text message. Also nicknamed as phishing capital of India, Jamtara, it got this title because there was numerous incidents of phishing across the country whose center point was there. In the span of 2 years between April 2015 and March 2017, police from 12 Indian states reportedly made 23 journeys to Jamtara. They did so to investigate cyber crimes, primarily phishing, that were emanated from one of the most underdeveloped districts, was responsible for 8% of them by some estimate. Does India need regulations like Europe, GDPR, General Data Protection Regulation, and United States of America CCPA, California's Consumer Protection Act? All of us would agree that data is one of the most valuable assets in current scenario. Data-related news laws is a global challenge. One of the efficient laws enacted globally are GDPR, General Data Protection Regulation. Europe's General Data Privacy Regulation, which took effect in 2018, not only gives privacy controls to individuals, but also places restrictions and obligations on organizations. However, unlike the rest of the world, which has privacy laws and regulations which aim to protect the privacy of citizens, India still does not have privacy laws to safeguard its citizens. In August 2017, the Supreme Court of India declared that right to privacy as a fundamental right for the Indian citizen protected by Indian Constitution. Following the right to privacy, India introduced Data Privacy Bill in 2019. However, it was withdrawn in 2022, and no new legislation has been proposed so far. India needs to set up its effort and have data privacy laws aligning global vision around data privacy. Thank you.
The next participant is Akash Dupla, and his topic is privacy versus technology, a caveat to right to privacy.
Currently in the so-called information age, which can be described as an era where economic activities are mainly information. This is due to the development and use of technology. The question arises here whether the advanced technology is important or privacy of information is. Good afternoon, one and all present over here. My name is Akash Dupla. It is an honor for me to speak to the honorable audience. As many researchers, it was that are not real, that we have the capability to collect and analyze data of internet researchers, telephone conversation, electronic payment, and personal information by various government agencies and business firms. Having this data is a market. There is a statistic found that 91% of adults own mobile phones or laptops, and our personal information is in the devices gathered constantly. In the 21st century, a government that cannot protect its citizens' right to privacy cannot credibly maintain a democratic regime for treatment under the law. We talk about privacy in Indian context. In 2017, the Supreme Court effectively declared that the right to privacy is a fundamental right as it is intrinsic to our guarantee of life and personal liberty under Article 21 of the Constitution. The government of India made a very efficient step by introducing the Personal Data Protection Bill 2019, which aims to provide protection for privacy and individual relating to their personal data. Specify the flow and usage of personal data, create a relationship of trust between personal entities, processing of the personal data, protect the fundamental right of individuals whose personal data are processed, to create a framework for organizational and technical measures in processing of data, laying down norms for social media, and to establish a data protection authority of India for the said purpose and for matters connected there or incidental there. There are various methods which can be used for privacy concerns, such as design method, privacy enhancing technologies, cryptography, and identity management. In brief, technology and privacy are going to continue to be a topic of debate for the foreseeable future. Technology is going to continue to advance, legislation continue to struggle. Keep up. One thing that is sure is that it is your responsibility to manage your data and your privacy. Be aware of that what you are doing and what you are providing data to. You can't get away from it. You are out there already. Thank you so much.
ये ठीक है? हाँ, एक मिनट देखिए. Thank you for your presentation. Participants, this is a reminder that you will only get 2 minutes to speak. The next participant is Rida Fatima, and her topic is liability of data protection, state and non-state actors.
Good afternoon, everyone. I am Rida Fatima, and I'm going to speak on the topic liability of data protection, state and non-state actors. How privacy is protected online is one of the most pressing issues of our time. The right to privacy is recognized as the basic human right under Article 12 of the Universal Declaration of Human Rights Act 1948. Right to privacy is a fundamental right which cannot be violated by any law. State and non-state actors play a wide role in data protection. Cyber world is a world without specific boundaries where people with a keyboard and mouse by a single click can visit whole world with certain apps can speak with anyone they wish can see anyone they want, may it be miles away. Mobile governance and fancy apps have become much popular worldwide, which have attracted not only intelligent and educated people, but also the general people from men to women, illiterate to literates, teenage to the adults. Cybercrime is a threat to national and international socio-economic, political, and security systems. State and non-state actors have a joint responsibility to protect privacy data and cooperate with law enforcement. When we download an application on our phone, why do we have to surrender access to our camera, photos, or contact list, and even messages for the application to work further? For instance, why is it that when we book our flights, our email provider stores our flight information and without our consent syncs it with the email calendar, reminding us our flight a few hours before the departure? In the year 2017, alone there have been 21 leaks and incidents of Aadhaar biometric data breach. Mukesh Ambani, the chairman of Reliance Industries, remarked in a leadership summit held in Mumbai that the fourth industrial revolution is connectivity and data. Data is a new natural resource. We are at the beginning of an era where data is the new oil. But at the same summit, he also made a reference to the impending challenges of this data revolution, namely privacy, security, and data theft. Governments take these kinds of steps to protect their country from external threats. Cyber hacking does not mean no loss to human life because hackers are human beings and they are causing injury to human society. On 11 September and July, attacks on the United States of America and UK are burning, painful, and measurable instances in contemporary scenario, which has impacted cyber terrorism. Those attacks are attacks to the world and not only to those two countries. House without knocking at his or her door, and this is equally possible both by the state and the non-state actors. It is an individual's choice as to who enters his house, how he lives, and in what relationship. The privacy of home must protect the family, marriage, and sexual orientation, which are all important aspects of dignity. Thank you.
A reminder will be provided after 2 minutes for your perusal, participants. The next participant is Prakhar Singh, and his topic is Right to Privacy, a view from constitutional perspective.
Thank you for the introduction. And I have only 3 minutes. That means the Chief Executive Officer have to play at a 20 match. Indeed, namaskaram to all dental lecturers sitting here and all my lovely friends. I am Mr. Singh with my intelligent friend Prakhar Singh, give a presentation on the topic right to privacy of constitutional perspective. So, let me ask a question. How many of you have no problem to giving your Instagram account password? Okay, only one person. Let us make it easier. Can anyone give me their mobile number? Many of them. So what is the fundamental reason behind this that you are not able to give your password, but you have no problem in giving a mobile number? Is the privacy. Because we all think that your Instagram account is your personal space and is your privacy. And I hope many of you may enjoy this privacy in the last week of Valentine. Nonetheless, let us come to the legal aspect of the topic. So the genesis of the right to privacy is enshrined under Article 20 of the Article 21 of the Indian Constitution. But much like the United States and United Kingdom, our Constitution also does not explicitly mention the right as a fundamental right in any provision. So it has become the duty of judiciary to take a step on this, and our Supreme Court take gladly this responsibility. And this is a craftsmanship of our Supreme Court that the right to privacy become the fundamental right by the virtue of series of cases starting from the SP Sharma and Kharak Singh in the year 1963. Although in those cases, the court doesn't recognize the right as a fundamental right, but the dissenting opinion of Justice Subba Rao in Kharak Singh case will eventually lead to the development of fundamental right as a right to privacy as a fundamental right under the part of Article 21 of the Constitution of Bharat. In the famous landmark case of Justice Swami versus K.S. Muthukumar versus Union of India. And this will make the right of privacy as a fundamental right, which can you exercise not only against the state, also against your neighbor and any individual also. So next part will carry a part by.
Thank you, Yashraj. India's commitment to privacy. According to Article 21 of the Indian Constitution, no one should be deprived of his life or personal liberty unless in line with the measures authorized by law. Broad interpretation holds that the protection of the right to life even of the Indian Constitution goes beyond what is essential for both human and animal survival. One of the aspects of life that offers man's life more meaningful fulfillment and value is the right to privacy. Thank you. Thank you all of you for hearing me consistently.
We next have Mohita Malik, and her topic is cyber fraud and its impact on the Indian economy.
Yeah.
A very good afternoon to one and all present here. Firstly, I'd like to introduce myself. I am Mohita Malik, a third-year law student from Amity Law School. I'm so glad you could join us today. My paper is titled Cyber Frauds and its Impact on the Indian Economy. In the words of Robert Mueller, there are only two types of companies: those that have been hacked and those that will be. Please switch to the third slide. Yes. Cyber fraud is a blanket term to describe crimes committed by cyber attackers via the internet. These crimes are committed with the intent to illegally acquire and leverage the sensitive information of an individual or business for monetary gains. Cyber frauds are becoming more frequent and varied as the population of netizens increases. These threats present a wide variety of dangers to an economy. The world's most lucrative targets for cyber fraud are developing economies like India, which are more vulnerable to cyber assaults and other threats due to the disruption caused by the pandemic. Please change the slide. NCRB registered 52,974 incidents of cyber crimes in 2021. The report of fraud was the highest in cybercrime, with a total of 3,142 cases. While the data show the severity of the increasing cybercrime rates, what's more alarming is that this data estimates the statistics based on only the reported cases. So the actual cyber fraud incidents would be even more if we consider the unreported ones. Please change the slide. The next one. Before you are a few types of cyber fraud that are most prevalent. We have malware, phishing, ransomware, virus dissemination, ATM fraud, and social engineering. Please change the slide. To meet the timeline for the presentation, we used the survey method and the purposive research design methodology was adopted. The sample size was 100. Please switch the slide. The responses to the survey questionnaire served as a foundation for the following analysis. As is presented before you, FA is for strongly agree, A is for agree, U is for undecided, D is for disagree, and SD is for strongly disagree. It is apparent that hacking is a serious crime in our society and is most prevalent, with a percentage of 64% strongly agree and 31%, but the least disagree was a percentage of 1%. Almost the same level of awareness exists for online extortion at 63%, software piracy at 62%, and ATM fraud 55%. Please change the slide. Cybercrime has and will continue to have an influence on all nations and economies that are using internet.
Fraudsters make use of the internet, computers, and other digital gadgets to aid their illicit operations as long as the monetary benefits outweigh the penalties if they are discovered. Please change the slide. According to Global Economic Crime and Fraud Survey 2022, India Insight, PwC, these are the top 4 most destructive frauds that had the most serious impact on Indian organizations, monetarily and otherwise in the last 24 months. Next slide. 95% of companies that encountered frauds in India experienced new incidents of fraud as a result of the disruption caused by COVID-19. Next slide, please. Knowing the extent of cybercrime as well as its economic effect is critical for both the government and business organizations. And it would be a useful tool in revising regulatory and legal frameworks as well as institutional frameworks. India is among the top 5 countries in terms of victims of cybercrime across the world, according to a report by the United States FBI. Loss of sensitive information, loss of trust among customers, and revenue loss is what results from cybercrime. I'll just be wrapping up. I'll just need another minute. To conclude, I would like to address the fact that the cyber world is growing. We now save more personal data online, such as financial data and phone numbers, than ever before. And as a result, cyber theft and manhandling with sensitive data are on the rise. It is reasonable to say that the surge in all of these cases is also due to the availability of internet connectivity. Privacy and security must be balanced while dealing with cyber transactions in order to preserve the revenue that is lost due to cyber fraud in cyberspace, which adversely affects the economy. Thank you.
Thank you for this lovely presentation, Mohita. We now have Shriyanshi and Sonika Yadav, and their topic is Facing Right to Privacy, Emergence and Evolution. Sir Edward Coke, while acknowledging right to privacy, said, "The house of everyone is to him as to his castle and fortress, as well as for his defense against injury and violence as for his repose."
Very good afternoon to all. We're going to speak on the topic Facing Right to Privacy, Emergence and Evolution.
In 2012, the Human Rights Council also affirmed that the same rights that people have offline must also be protected online, in particular, freedom of expression.
Civic right to privacy is deemed essential to a person's freedom and dignity. Fundamental human right, privacy is recognized. Expression of human rights, human dignity, and other values are supported by discretion. It is currently one of the most crucial human rights crises in history.
Quoting the famous Khara Singh judgment, it goes, as already pointed out, the right to privacy is not a guaranteed right under our constitution, and therefore the attempt to ascertain the movements of an individual, which is merely a manner in which privacy is invaded, is not an infringement of fundamental right guaranteed by Part 3. Justice Subba Rao dissented with the majority judgment, asserting that although the Constitution of India does not explicitly mention the right to privacy as a fundamental right, yet such a right is of most importance for the personal freedom of an individual. The Maneka Gandhi case accepted the dissenting judgment of Subba Rao and Khara Singh. The right to privacy is the right to be let alone. The issue whether the right to privacy comes under Part 3 of the Constitution of India was resolved in the 2017 case of Puttaswamy. It goes, protected right that emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution. Elements of privacy also arise in varying contexts from the other facets of freedom and dignity, recognized and guaranteed by the fundamental rights contained in Part 3.
Primarily, Indian laws deal with e-commerce and cybercrime. The Information Technology Act 2000, the Information Technology Rules, are currently at the forefront of what can be perceived as India's data privacy. It holds corporate entities accountable for protecting sensitive personal data and information.
To end with, privacy is not something that I'm merely entitled to. It's an absolute privilege. Thank you so much.
This is very mental level. But please
We next have Mukta Singh and Isha Tripathi with their topic, Right to Privacy and Data Protection in Digital Era.
If we don't act now to safeguard our privacy, we could all become the victim of identity theft. Good afternoon, everyone. Today, I am Singh, along with my teammates, Mr. Shashik Vajpayee and Isha Tripathi. We are going to represent the topic. Talk to you on the digital era. That is the right to privacy. With the widespread in our daily life, that is collected, stored, and used has increased dramatically. Is being used. That's right. In recent years, we have seen numerous examples of data breaches and privacy violations. From the Cambridge Analytica scandal to the recent SolarWinds hack, these incidents demonstrate the vulnerability of our personal data and need for stronger protections. The Unique Identity or UID initiative has been depicted as a new phase of the technology which has the potential to bring a change. UID strives to build up recognition and legitimacy by launching of many government schemes that require UID as a mandatory law, which helps the city succeed, passport in under 10 days, driving license, and many more. But there are certain issues regarding privacy being affected for an individual at the launching of this initiative. Privacy infringement. The right to privacy is enshrined in international law and it is considered as a fundamental human right. It is essential for the protection of our anonymity and dignity. In the digital age, threatened by the constant collection and analysis of our data. It's often without our knowledge and consent. However, it is important to note that privacy is not absolute right. It must be balanced against other interests such as national security and public safety. But this balancing act must be done in a transparent and accountable way. Exactly. Governments and corporations must be held accountable for their data purchases, and individuals must have the right to control over their own data. There is a BN Sri Krishna committee came into existence by the government as a duty to defend citizens' rights. This means providing clear and information about data collection and usage, as well as giving individuals the ability to opt out certain data practices. We also need stronger laws and regulations for privacy in the digital age. Justice K. Puttaswamy versus Union of India, a 2017 case, acknowledged as right to privacy verdict. It is a landmark decision of Supreme Court of India. The 9-judge bench held that the golden triangle of the Indian Constitution, which are Articles 14, 19, and 21, protected as the right to privacy is protected as a fundamental right. The right to privacy is a fundamental human right that must be protected in a digital age. It is up to an individual and as a society to demand stronger protection and hold those who violate our privacy accountable. Thank you for listening. We next have Ramkrishna Beghe and Yasharat Tiwari to present their paper on right to privacy, individual right or social contract.
Good afternoon, one and all present along with myself, Ramkrishna, along with my co-author, Yasharat Tiwari, is here to discuss on our research topic, right to privacy and individual right or a social contract.
To be free from interference and incursion is what a person derives from the word privacy. Privacy is the human right to which we didn't get embarrassed by birth, but with the revolution and modern civilization, it gets involved as the fundamental right. Privacy is a basic human right. It promotes human nobility and other values such as freedom of association and freedom of oration. Often, privacy claims clash with the first modification right. For example, individuals may assert the privacy right to be let alone. The press reports on their private life or follows them around in the intrusive manner of public and private property. We also have some family privacy. Every family have different situation and different reasons. So we don't want anyone to know about that, and no person will try to question us on that. Ask us or circle of relatives. Non-public topics is if any character knows about them, then he she have no longer harm than praise. There are four states of privateness: solitude, intimacy, anonymity. These are those states that needs no balanced participation in opposition to norms. Technological threats via social contracts. To take one example of the methods in which generation would possibly adjust the situation of a social contract agreement, the capability for individual enhancement through technological manner shows that very simple sorts of equality, early settlements theories have been able to presuppose are no longer confident. The collection of records approximately individuals, which now occurs on a scale distinct from something that changed into a viable and possible before in a major project to a conventional social settlement. To be able to afford the social settlement, such legal guidelines have to obtain two main matters. They have restrained the one entity, manipulate or disproportionate number of statics, and they have to make sure the enforceability of such laws. Extra importantly, the viability of social settlement with its requirement of voluntary affiliation rests upon assure other goods, the contractors, that such enforcement is purposeful. Now over to you.
Thank you, Ram. So doing a deep research in this field, we can now conclude that the right of privacy to which the person is enshrined in is not only his or her basic human right, but it is the privilege provided to them through the Constitution and through different apex bodies related to it. Right to privacy can be now considered as an individual right. The fundamental right or the privilege is somehow limited to certain boundaries due to emergence of digital era and the development in the field of technologies. The term social contract has been arises, which is none other than the mere contract. Thus, we can now say that though the right of privacy is an individual right, it is more concisely a social contract, as in this digital civilization, no one is left using the current technologies, and as a result, the transfer of data is obvious. There are certain threats because the social contract is the arena of privacy. Thank you.
We next have Nisha Singh to present the topic cyberspace and interpersonal relationship. Cyberspace, a consensual hallucination experienced daily by billions of legitimate operators in every nation by children being taught mathematical concepts. A very good afternoon to everyone. I, Nishtha Singh, is present before you to present the topic cyberspace and interpersonal relationship. What exactly is cyberspace? Cyberspace is a virtual world which was actually introduced by the book of William Gibson, named as Necromancer. The word cyberspace gained its momentum and was later recognized into dictionaries and then was used as a plot for various movies. According to Sanjeev Pillai, cyberspace is a human-created digital medium to collect, store, and transmit data and information. That cyberspace is an artificially
created domain that provides interpersonal relationships for people by connecting them with each other using electromagnetic spectrum. The cyberspace is an ever-widening environment with new platforms being introduced periodically. The most recent add-on space is ChatGPT. ChatGPT is generative pre-transfer, which uses artificial intelligence and extracts data from internet and answers queries in a summarized format. The structure of cyberspace is three-dimensional. The layers being physical layer, logical layer, and the cyber persona layer. The second part of the presentation is the impact of cyberspace on interpersonal relationships. There are several impacts, being the positive and the negatives. The positive is it helps to boost connectivity across the whole world, and it helps in improving communications. The negative being cyber crimes and privacy invasions. Such an instance can impact a person, which might reflect in their interpersonal relationships. Then other two negative impacts being it fuels functional impairments and decreases quality time between people and decreases relationship satisfaction. In order to conclude, I would like to say that cyberspace is a promising domain to share ideas and to connect with people globally. But it is us who has to use it wisely. In the words of John Perry, we will create a civilization of mind in cyberspace. May it be human and fairer than the world we live in. Thank you.
We next have Utkarsh Tripathi to present his insightful thought on this topic.
Good afternoon to Honorable Chair, Co-Chair of the session, organizers, and to everyone present here. I am Utkarsh Tripathi, student of law from BBAU, and I am here to present the paper on the topic of liability of data protection, state and non-state actors. Modern era, new necessities, data and internet. Today's world oil is data, and whoever will command data will rule the world economically, socially, and politically. Might is right will fit reality, as state would be weak in three, that is economic, social, and political sense. But it would be the puppet in the hands of elite, and the welfare of the common people is going to suffer, and elite class is going to dominate the world, and it will widen inequality and poverty due to chronic capitalism. So state should control this big data storing giants and make laws regarding it. Though difficult, but it's possible, and most successful example is US, that is CCPA, and the EU itself, that is GDPR, that is General Data Protection Regulation. And this GDPR is very stringent, and it's really valuing the right to privacy to the greatest extent as in the present time. And the Supreme Court has also upheld the right to privacy by giving many judgments, and one of the most valued and the landmark judgment, that is KS Puttaswamy versus Union of India. And many judgments have also been given regarding it. But the government of India is inactive in this. They are bringing many new laws regarding it. That is, India has told that all data of the India should be stored in India. These are encouraging steps taken by Indian government. So as we demand RTI from the government, the same should be applied to these enterprises that are in our territory. As government is not allowed to share our private data or even include in it until the question is of sovereignty. Same should be applied to the organizations along with a check on the government and organization that no private data should be accessed. The challenges or issues are intellectual property rights, protection of minors, and right to be forgotten, anonymity, privacy and data protection, freedom of expression, information, and communication universal plus equal access. You can see that even Supreme Court has upheld the right to privacy under Article 21 by stating that everyone has life, right, and they are free to have privacy. But the Supreme Court says that no law is absolute and there are some reasonable restrictions on it. But it is reasonable and it is reasonable, not unreasonable. And also we should know that if we have more freedom, then it means we have more responsibility to act responsibly. Supreme Court also stated that right to privacy is needed so that the state could not exercise enormous power over the freedom of people. Because if we are a democracy, then it should have characteristics of democracy. And one of the greatest characteristics of a democracy is freedom of expression and etc. So we need to give people more freedom and along with that fulfill obligation towards their democracy. Supreme Court also advocated right to privacy so that people have voice. That is what is a problem at the general level, at the ground level, that is seen and sorted out. And the elite class don't lead the society according to their whims and fancy. That is exploiting the rights of the deprived section by their money and muscle power, and along with their influential capacity for the state, so as to reduce even the authority of non-state actors and strengthening of democracy. So conclusion is privacy is needed and it should be upheld and valued. Thank you.
Thank you for this lovely presentation. We next have Vanshika Ashu with the topic human rights.
Good afternoon, everyone. This is Vanshika Ashu from third year, and I'm presenting the research paper on behalf of Ujjwal Pandey, a student from Banasthi. The concerned research paper revolves around the topic of human rights. The research paper to be presented highlights the idea such as history of human rights, nature of human rights, Universal Declaration of Human Rights, and the contribution of High Court and Supreme Court in the recognition of human rights. With the human rights are universal and applicable globally. In nature. Regardless of age, gender, sexuality, origin, caste, religion, etc. These rights give very basic and nominal right to any individual, being human itself. Human rights developed recently. We reach basic fundamental rights to make life worth living, such as right to food, right to education, right to health, and liberty. It's well elaborated in the research paper that the human rights ancient times where the law was based on dharma. In that period, they were essence of social, political, cultural, religious rights, whereas the advancement of Mughal Empire results in the loss of human rights. After modern era, the Britishers happened to exploit the norms of human rights, all religious, political, social, and cultural rights. After independence, all the rights were revived by the Indian Constitution. The nature of human rights are universal and inalienable. Are universal in nature, emphasized in the UNHCR, is repeated in many international human rights conventions, declarations, and resolutions. Human rights are individual and interdependent. Means one thing cannot be enjoyed without the other right and interlinked with each other. They are equal and non-discriminatory. UNHCR states all human beings are born free and equal in dignity and rights. The rights include obligations and rights. All states have ratified that at least one of the 9 crore human rights treaties
As well, one of the 9 optional protocols, eight states have ratified 4 or more. Means that the states have obligations and duties under international law to respect, protect, and fulfill human rights. Emphasis on Universal Declaration of Human Rights, UDHR, which lists 30 rights and freedoms such as civil and political rights, and social and cultural rights. Keshav Bharati was the state of Kerala. The Supreme Court stated that the Universal Declaration of Human Rights may not be legally binding instrument, but it shows how India understood the nature of human rights at the time of Constitution was adopted. The contribution of Supreme Court in recognizing and highlighting the idea of human rights. In the year 2019, the hearing of Punjab State Human Rights Commission versus Jharkhand NHRC judgment. State supplied the other and specified to settle the HRC Human Rights Commission. The bench said this court does not consider it essential any additional judges or infrastructure till the judgment of the court is not executed. The Supreme Court issued chief secretary to know why chief secretaries need not to sue such direction. Very famous case law, which is entitled as Shah Bano case law. Supreme Court granted maintenance to Shah Bano and protected the rights of Muslim women beyond the personal laws. Despite this, Muslim community considered this specific wording of the court and defines the Muslim Sharia law. Therefore, Parliament ordained All India Muslim Personal Law Board 1973. The paper also discussed the Protection of Human Rights Act and recognized the Indian government establish the human rights with the particular act. It also elaborates the salient features of the Protection of Human Rights Act. And to conclude, I would like to say human rights, basic rights, which form an essential part of his or her development as human being. Constitution Act has the predicate of basic rights as fundamental rights and DPSPs. More emphasis to the fundamental rights have been given and they are directly enforceable in the court of law. Judicial has also taken great steps such as relaxing the rules of local standard. Now, any other person in place of the ones affected can approach the court. The Apex Court has integrated the fundamental rights, labor towards citizens, rights like right to privacy, right to fair employment, right to free legal aid, right to fair trade, also find its place in fundamental rights. Thank you so much.
Thank you so much, Panch. We now have Vijay Bharti Srivastava present a paper on Constitution, Construction of Right to Privacy as Fundamental Right.
That right in that when the persons have natural law right since the advent of the society. It existed in the minds of the persons since ancient times as their right. It is correlated to the personal liberty, dignity, and autonomy. For the framers of the Constitution missed to be expressly mentioned in the Part 3 of the Indian Constitution. The judges of India were considering positively about this right since 1950 in the A.K. Gopalan's case, but could not broadly interpret the life and personal liberty as requested by the petitioners because it was not come specifically in the Constitution. The Constitution took 3 decades up to Menka Gandhi's case 1977 to interpret broadly Article 21 and to give way to the several rights under this article. The Renaissance period came in the Indian judiciary in 1977 when Article 21 was constituted in Maneka Gandhi's case, the protection of life and personal liberty, Article 21, which became the heart and soul of the Indian Constitution, was interpreted in right to move freely under Article 19 and 21 altogether. This has been just came after the end of the emergency period, where many atrocities and excesses were done by the state with the persons of the opposite party and others. The courts started interpreting liberally in favor of the people's fundamental right. Many amendments in the constitution favoring the state were done, which were abroging the rights and freedoms of the people of India. Later, other amendments in the reserve and to secure the rights of the people of India were also done. The right to privacy could still not be interpreted freely by the courts because the adverse finding, even in the case of decide a larger benches such as maximum 8 judges of MP Sharma's case, and in the meantime, Justice K.S. Puttaswamy retired, filed a PIL to save the right to privacy of the people. Then, when the government was connecting many private information to the Aadhaar card, the income tax returns, the bank accounts, and the sale and purchase of the property, etc., were linked to the Aadhaar card. The online data on computer data space, Facebook, Instagram, Twitter, etc., were also preserved through mobile phones. This all were the danger of the cyber frauds of many kinds of this modern age, and almost all the people are online. The duties and the responsibilities of the government have been placed to save the people's data from cyber frauds. It is duty of the state to restrict the demand of the Aadhaar card. And finally, I have in my research paper I have taken three period for this. That is the post-Maneka period, pro-Maneka period, and post-Maneka period, Maneka period, and post-Maneka period. In the pre-Maneka period, I have started from the A.K. Gopalan 1950 because MP Sharma and Hudson's case were based on the A.K. Gopalan's case. And the other case was in the 1975 in the Govind's case when the took the positive view. And since the Maneka Gandhi's case and after the Malak Singh case, Raj Gopal telephone typing case, and Mr. X versus Hospital Z cases were the prime cases where the right to privacy was in the last the report of the Justice B.M. Shrestha, which was the very important thing, and we hope that this law should be made by the Parliament and their restrictions should also be in that constitution.
Thank you so much, sir. To quote Mitch Albom, every ending is a beginning. We just don't know it at that time. With this note, we're heading towards the end of this session. Hope you gained your share of knowledge. But this session is incomplete without the blessings of our esteemed guest. Now, I would like to call Professor Dr. Alok Kumar sir to share his words of wisdom with us.
Thank you. Very good afternoon. First of all, I congratulate whole organizing committee organized such a seminar on a very burning right to privacy and data protection in digital era. This is a big challenge before the government to pass effective act which can deal with the issues regarding data privacy in digital era. So, in various cases, Supreme Court and other high courts have recognized this right to privacy as a fundamental right. But the problem is that how this right can be protected in digital era. There are a number of issues like facial recognition and data mining, etc. But in lack of any law, effective law, only the issue is
directly governed by IT Act. There are some provision in IT Act like section 43A and 72A, and some exceptions has been given in section 69. Only these are some sections which can deal with the issue. Come to the paper presented by the students. It was a very nice part. All students tried their best to present and incorporate the issues relating to right to privacy, especially right to privacy in digital era. So congratulations to all of you for your effort and presenting wonderful papers. Thanks. Thanks to all.
Thank you, sir, for your words. Now, I would like to call Professor Dr. Preeti Mishra ma'am to grace this event with her words. Thank you, Anisha. First of all, I would like to thank Professor J.P. Adoti, Director, MIT Law School, for inviting me here and listen to such budding lawyers and academicians of the future on this burning topic of today, that is right to privacy and data protection in digital era. Issues and challenges. I would also like to pay my regards to Professor Asad Budiki from the University, my co-chair, Dr. Alok Kumar Yadav. We had in this session, and I would also like to place on record my best wishes to my dear students who are teaching here, Shasha Mishra, Dr. Rajiv Kumar Singh, Mudra, and all other faculty members for putting their best efforts in organizing this program. So, with this words of regards and gratitude, I would like to say that the topic which was for this conference was right to privacy and data protection and digital era issues and challenges. So most of the papers emphasized upon either right to privacy or on the data protection. We could have the lesson less thought on combining both the topics and emphasizing more upon the issues and challenges. Because we all know that in today's digital era, where there are state actors as well as non-state actors, we have social media, and so much data is there on the social networking sites. Because daily we are using our mobiles, our laptops, we are on Facebook, Twitter, on Instagram, placing a lot of information about ourselves. So, though there are cookies on the internet, and we are also conforming to the terms and conditions when we are using these social network sites or anything, accessing any kind of information on the internet. We do not know, but we are being watched by everyone around us, and even by those who are alien to us. If we are sitting in our dining room, in our classroom, or in our sitting and in front of our laptop, we feel that only two are here, me and my laptop, but several eyes are there watching us and what we are doing, what kind of activities we are indulging in on the internet. So this data, which is being voluntary or involuntary being disseminated by our own part in this digital world, it really sometimes becomes very, very scary when we get some kind of anonymous calls or anonymous messages, or like you mentioned, a lot of cyber crime on the internet, spoofing, phishing, and etc. So many things are there. So sometimes it's really becomes scary that what to reveal and what not to reveal. So there has been a demand on stringent law for the data protection. And government has made the effort, and present bill, that is their digital data protection bill 2022. And the public voices were also invited on this particular bill. And we could hear very little less in this presentation. There were 15 presentations talking about right to privacy, about cyber fraud, and
various other things, but little about the present bill. What are the shortcomings, what are the issues, and what can be the challenges, what are the merit and demerit of this particular bill. So I would like to you all students to go through this bill and point out your critical views that what amendments are required or what more need to be added with this particular bill, because you all are young minds, very energetic, and looking around the world in a different perspective, because we have got old glasses now, but you are having the new glasses, see this world from your own eyes. So you can better, because you people are more on the social networking sites, because many of us are not on the Facebook or Twitter, never on Instagram. So we may avoid ourselves by not using these. But in present world, it sometimes becomes very incumbent upon us to do these things. So we have to be very, very careful. So I would like to thank the organizers for organizing this wonderful conference on this very relevant topic of the present times. And we had some really very good papers with the empirical studies also, good PPTs were there with all the relevant points. And we have marked it and it will for the business to see. And since it is already late and we are running late, so I would not like to just to so much light upon it, because the right to privacy itself is a very, very debatable issue. That what should come within the domain of right to privacy. Because not only the Puttathwamy case, before that also more than 50 cases have been there, even or more than that, on discussing the right to privacy and various aspects of it. Because right to privacy itself are very, very something very, very intrinsic to a person. Right to be let alone, right to be oneself, not to be disturbed by others. So there will be so many things, not only our physical activities, but our. So it is itself a very, very gray area to discuss. And I think that even the Supreme Court has not touched many of the points, even in Puttathwamy case. And so for data protection is there. If you look upon the provisions of the bill, we find that the bill talks only about the digital data and not about the manual data. So we do need protection about the manual data also that we generate each and every day. So with these little words, I would like to convey my regards to the organizers and to all the participants to put their best foot forward in future in all the academic activities of the school. So thank you all. Thank you so much for giving me time and sharing some of words with you all. Thank you so much. Thank you.
Thank you, ma'am, for your kind words. Now, I would like to call Professor Dr. J.P. Yadav, sir, to give the vote of thanks and end the session with grace.
Thank you very much. Good afternoon to one and all present in this food court hall. It's an honor for me to give a vote of thanks to respected Professor P.T. Mishra, Head of the Department of Human Rights, Babasaheb Bhimrao Ambedkar Central University. Ma'am, me and my department and my students remain grateful to you that you spare a time for us from your busy schedules. Thank you very much. I also grateful and thankful to Dr. Alok Kumar Yadav, Associate Professor, Department of Law, Lucknow University. Sir, you spare a time from your busy schedules. For that, indeed, we all are grateful. And your words of wisdom are also encouraged to our students. I also thankful to the students who present the paper in this session. Certainly, this is a very pleasurable moment for me that you take this opportunity and avail this opportunity and to express your view on this forum. Such types of opportunity, whenever you get during your academics, during your journey of study, and apart from when you go into the
senior levels, then we also avail this opportunity and present the papers. Because by this way, when you prepare the papers, when you write the articles, then you do some research. Now, it is very unfortunate that the tendency of reading and writing is going down because you always believe on the digital resources. You read from the Googles and all other websites, but pen down, writing an articles, this is really goes down. I'm full of info that my maximum students present the paper in 40 technical sessions. This is very encouraging things. And really, we are able to inculcate the value of the seminars or the paper presentations in this various technical sessions. So I'm thankful to all the students who present the paper in this session. My best wishes to the rest of the students paper presented in the coming sessions. With this, thank you to all once again. And now the lunch is waiting for you in EP4, I think. EP4 में कहाँ पे? हैं? VIP room. Thank you very much.
With this, we end the session. The participants can move to the auditorium to have their refreshments.
Respected director, sir, as a total of please to please give a round of applause. Again, I request respected director, sir, please give the memento to give the memento. Please round of applause.
इसको साइन आउट करते हैं इसीलिए डरते हैं वहाँ माइक ऑन बोले थे अगर हम यहाँ बढ़ा देते तो अभी स्पीकर बनता समझा छोटे से
in evident volumes and journal practice and presented papers. He's also an expert panel on oral the radio for social for it is a pleasure to have you among us. Second, now, this platform is proud to be right. Please,
अच्छा आपका लैपटॉप हाँ टेस्ट का होगा टेस्ट
now I request Anisha to take over the podium.
ओपन नहीं इसको डिस्कनेक्ट कर लो तो उधर बात करो हम लोग क्या हो गया उसका लास्ट
The previous book by Frank Kafka describes begins with a man being arrested but not being told why. Of course, I have compiled a dossier about him and officials who made his decisions about him. But he was the one who was left in the dark.
एक से
This house of case today, which is hampering the right to privacy. By the level of development in the field of technology, there are unanswered questions which follow the path, as well as here we are to show various aspects of data right to privacy and the issues challenging revolving around it. As it is said, great work always seems impossible until we started. And on that note, with plethora of gesto, we now commence with the session. The first participant is Tulip Sharma. I call her to take the podium.
हाँ बस शेयर कर बोला स्ट्रीम एक डुप्लीकेट
Greetings of the day to the respected dignitaries. Before I start my presentation, I would like to give a brief introduction about myself. My name is Tulip Sharma. I am from Amity Law School, Chhattisgarh. I am also PLLB and I am in my third year. My co-author is Sanju Tiwari, also from Amity Law School, Chhattisgarh. So the title of my paper is Liability of Data Protection in India, State and Non-State Actors. Now, over the last few decades, cyberspace has expanded powerfully and this is linked to the protection of data. Now, the threat of data, the threat of privacy now over the citizens, but we lack of complicated that deals with the data protection. It is not a that surveillance is an part of the 21st century. So we have how much surveillance is too much surveillance. Now, we have also shed light on the growing role of the non-state actors and the security threats that are posed by them. We have also done a comparative analysis about and countries like the UK and US to better understand about the international efforts that are being made towards securing data of the citizens. Last but not the least, we have also proposed some suggestions for effective legislation and for machinery that will help in securing data. Now, the concept of in the case that one, it was held to be a fundamental right. Now, India however, India lacks in conceiving. To fill this glaring gaps, the government also introduced the data privacy bill 2018, but it addresses the issue of data surveillance. So we have also highlighted this issue in our research paper. We have also mentioned some of the leading case laws that are helping evolving the digital jurisprudence in India. So as we go to the analysis that we have done in the paper. First, we have discussed for two models, the generalist model and the safe harbor model. Safe harbor model is mainly prevalent in India, wherein the intermediaries are not held liable for the activities that are done by the third party, and their liability is primarily determined by the circumstances. Further, we have also discussed about the companies like Apple and Mozilla who have made earnest efforts to safeguard the data of their users. However, there are many companies who are reluctant to do this, and they're insensitive when it comes to protecting the data of their users. So what we have proposed is, besides the concrete legislation, what we need is that companies must appoint a data protection officer, and we need a strong worded regulatory framework like the General Data Protection Regulations to further the cause of data protection. We've also discussed about some of the international benchmarks and covenants like the UPHR and ICCPR, and a major highlight about these covenants so that India can draw inspiration from these covenants. In total, to sum up all the important points that we have made, the current laws are not sufficient. The government should, in the course of safeguarding national security, should not intrude into the lives of the citizens, and there should not be a blanket interception. Like, despite the progressive landmark ruling of K.S. Puttaswamy, the existing laws need an overhaul when it comes to the privacy issues, and the equitable share of responsibility between the state and the non-state actors is the only way forward to make cyberspace an inclusive and a safe forum for all the citizens.
Thank you so much, Tudor. We next have Ronak Kumar Mishra to share his.
नीचे कर दो, अरे नीचे करो, पीपीटी को शेयर करो, हाँ शेयर बदल हाँ पीपीटी हो जाएगा।
Good afternoon. Secretary. I and here I am presenting my research topic about ribbon formula. The title of the paper is Monarchy of Nature and the purpose of ribbon formula in India. Basically, what is ribbon formula? According to the eminent Juris Citroen, it is basically acronym for the distribution of textual and intimate photos that link with the personal information which has caused the harm, which is intended to cause harm, the damage of reputation and personality. Is anyone else? The term event formula come into light when in 2010 a site called Is Anyone Up come into existence, and within 3 months of there were more than 8,000 of posts that were published there. After that, it was removed from the site, but this was the first instance that event pornography come into the mind of the people. Objective behind the research paper, basically this paper emphasizes on the current legal framework of the available to the victims regarding the revenge pornography, and this also try to bring what are the psychological trauma that are faced by the victim and that are unaware by the perception of any person being a victim of this event. Research methodology. Basically, this research was conducted and here combined the 100 respondents and their profiling was based on the gender basis, age basis, relationship status, and educational level. Data that was collected for this research was collected by the mean of questionnaire. Here it comes the respondent profile. Here it shows 67% of the respondents were female and 33% of them were male. This paper basically come up with two main analysis. The first one is positive awareness among the society. It basically shows more than around 30 to 33% of victims weren't even aware about what is going on with them and what are the legal aspects related to that and what are the remedies available to them. This paper also throws some light on the reason. Breach of trust, criminal breach of trust happened. Some of the respondents blame around 52% of respondents agree with the and the victim. 70% of people say that victim itself is liable for the said act. 30% chooses not to pay anything, and 80% of them there's a mutual malpractice that went wrong. And here it comes to variances. Some we have got some victims those who are ready to share their experiences in spite of what happened to them. They say the fear and anxiety it creates can creep into every corner of victim's life and relationship. It's absolutely unacceptable and it can never be the victim's fault. One of the victims is most of the victims of crime suffered long-term anxiety and some mentioned feeling of self-harm and suicidal tendencies that their intimate image was shared without their consent. Coming for the legal provisions that during the course of research we found that there are segments that they are not aware about what are the remedies that are available to them. Though in India we didn't recognize revenge pornography as a crime, but we recognize but we didn't have a proper institute regarding that. We choose our municipal law to govern the crime. Some of the provisions were given under the IT Act 2000, such as 67D, 6768, and 72 of the IT Act. Under the Indian Code, there are translation of obscene articles and obscene photos. And under there is a statute that made indecent representation of women. That also talks about the representation of women, not to be shown in an indecent manner. During the course of research, author suggests a computer responsive identity that may be named CRT-IP, and that should be governed by both. There are certain guidelines that there are certain provisions that author incorporated in the paper, and there are certain limitations. The limitation to the research paper was the territorial limitation, time restraint. Respondent was hesitated in sharing the feeling and that they went through that time, and obviously the feeling. Thank you.
We next have Krishna Ajay to share his views.
Good afternoon, everyone. This is Krishna, and my topic is research and challenges. A cyber attack is when there is a deliberate and malicious attempt to beat the information system of an individual or organization. While this is economical goal, while some recent attacks show destruction of data as a whole, malicious hackers often look ransom for some economic gains, but attacks can perpetrate it with an array of motives, including political activism. Social engineering is often looked at, but it threats the human factor to bypass information. Social engineering often impersonates authority and often tries to lure their victims into volunteer security restrictions. Phishing can be referred to an attempt to steal sensitive information, typically in the form of username, passwords, and bank account details in order to sell stolen information. Then I would like to talk about ransomware. Ransomware is a type of evil software that tries to publish or block access to data or computer system, usually by encrypting it. While the victim pays ransom fees to the attacker, in many cases the ransom demand comes with a deadline. If the victim doesn't pay the ransom in time, the data is gone forever. The ransom is increased. I would like to conclude by mentioning some recent data that took place in last year. NVIDIA faced a ransomware attack in February 2022. Indian Airlines SpiceJet also faced an attempt of ransomware attack. Twitter faced a phishing attack in July 2022 and asking Bitcoin in return. Uber discovered they were hacked in September 2020. Thank you.
We next have Vikas Yadav. The topic, recent trends and challenges in relation to right to privacy.
That is a concept of everyone that is here. This is Vikas Yadav presenting on right to citizen and data protection in digital era. Issues, challenges, and recent trends. And in the morning, Triveni sir has already explained what we are facing today in how the people are using data and misusing our data, and from the cloning of the debit card and cloning of the Aadhaar card fingerprint, as in IPS sir has already said. The right of privacy is a fundamental right protected by the Constitution of India despite their privacy. As said by the Puttaswamy, Justice Puttaswamy in the case in which he said, in the landmark case of Justice C.S. Puttaswamy, Union of India, the Supreme Court held that privacy is a constitutional right, and it encompasses preservation of personal intimacy, the sensitivity of family life, protection of personal autonomy, and protection of dignity. The right of privacy is an element of various legal traditions to restrain governmental and private action that threatens the privacy of individuals. India, a democratic country, recognizes the importance of privacy, a fundamental right, and has incorporated it as a part of Constitution under the Article 21. Defining the right of privacy, the digital era has brought about the revolution in the way we live and work. With the proliferation of technology and internet, a vast amount of data is being generated and shared. This has led to concern about the protection of data, the right of privacy. From the rules of 2011 under the Information Technology, the digital era led to the increase in the cost of data, which is the concern about the privacy and data. There is a need to address these concerns and ensure that personal data is protected regardless of where it is there or generated. The digital era has brought about the way they live and work, but it has also raised concern about the protection of personal data and right to privacy. In India, right to privacy is a fundamental right. Data protection is regulated by information technology. These level security practice, procedure, and sensitive personal data or information to 2011. Some of the recent trends and challenges relating to data protection are ransomware, data mining, phishing, social engineering, attacks, dismissing, and fear resistance and right privacy. The widespread use of technology and the internet has led to the increase in the collection, storage of personal data by various entities, including the government and private companies. As a result, concern about the data privacy has become more prominent, with many individuals worried about their personal information to be misused or disclosed without their consent. Supreme Court verdict on right to privacy 2017. The Supreme Court of India declared the right of privacy as a fundamental right protected under Article 25. Relevant case law, Justice J. Sir, it goes without saying that no legal right can be absolute, with every right has limitations. This aspect of matter is standard at the bar. Therefore, ever, even fundamental rights, limitations. Second case, in district registrar and collector, Hyderabad versus Canara Bank, a bench of 2 judges of the Supreme Court considered the provisions of Indian Stamp Act 1899, Section 33, which invalidated the High Court empowered the collector to inspect the register, books, and records. At last, not the least, I am concluding my research on the cybercrime in India and its related significant issues, especially from the socio-economic standpoint, particularly those from the socio-economic background who may be more susceptible to exploitation, abuse, cybercrime, have severe impact on people. Thank you.
We next have Manas Mishra with the topic. Piece of digital
हमारे पास है पीपीटी है ना मानस का लास्ट
Technology is challenge to make balance to deal with such a huge challenge, the Supreme Court of India pronounced landmark judgment, Justice K. Puttaswamy and another versus Union of India, 2019. Individual freedom and autonomy in democratic society and working for maintaining the element. Coming on the objective of my research is to examine the constitutional provisions that carry the right to privacy in India and analyze the evolution of the interpretation by the court, evaluate the effectiveness of protection mechanism protecting right to privacy. Coming on the historical background of right to privacy in India, huge student, we start by Charnak, Quran, and Kafa teacher have dealt with the privacy rights. According to how to increase the request of any family, include guidelines for big homes and arranging living spaces in a way that supports privacy and secularism. The platform and measure other features explore the nature of the self and the importance of individual autonomy.
That Uttara Purana contains a lot of stories regarding the privacy and other aspects of Adharma. Further, in Islamic jurisprudence, we have concept of hayat, in which Quran has prohibited a lot of things like one cannot enter the house because and personal messages of others not read or interfere for enter or other family members. Coming about right to constitutional. Further, here the Indian Investment Act, which under which a person is entitled to privacy of their property, including home, and cannot be disturbed by others unless it is for lawful purpose without their consent. The nexus of right to privacy of India is there. First and foremost, coming on the Constitution Assembly debate, in which Dr. Bhimrao Ambedkar and KM advocated the inclusion of right to privacy in the Constitution Assembly, and which was opposed by B. Rao and Alani Swami. Again, in 1947, Somnath Nehru opposed right to privacy, and at last, it was moved by Qazi Sayyid Kalimuddin to include the right to privacy as a fundamental right, and it was against unreasonable searches and seizures in the Constitution. That was objected by Islam. Further, coming on the constitutional provisions, here are in my research, the ambit of my research is Article 21, Article 19, and Article 20. Article 21, in the case of India, was held that right to privacy is an integral part of Article 21, that right to life and personal liberty. Article 19, freedom of speech and expression. The case of this is the heart of Sangha, which is traditional 1994 study and Article 20 coming on the documentation report and right to privacy. First and foremost, it was recommended by the 42nd report of the documentation that was in 1971, the inclusion of new chapter in ICC, that is against offenses against right to privacy. The second report, 156 report of 1997, which recommended that there should be separate distinction should be created to address this problem. And in the 20th report, 2000, after the committee of Justice Jagannath Rao, in which it was content of 1971 was discussed, and the immunity granted to publication is stating that the publication would only be contemptuous if a criminal proceeding is pending. And in this report, Metcalfe principles were that previously considered coming the leading case was the right to privacy. That is the first and foremost case is the MP Sharma versus Submission, then in which section 94 and 96 of the were challenged, and the court held that there is no provision in the Indian Constitution that guarantees right to privacy. And the second case was Khadak Singh versus state, in which regulation 236, that is dealing with the surveillance of anti-police regulation, was challenged on the ground of breach of privacy. In this landmark case, it was held that life means something more than breathing or animal existence. In this case, domestic visits were to be made by the policeman in the form of harassment, and which led to the breach of personal liberty of harassment that was against the provisions of Article. The third case, in which the first and foremost, the right to privacy was Govind versus state of MP, in which regulation 8 of MP police act was challenged, and the court determined regulations were valid, but citizens have right to privacy in the Article 21. However, this right is not obsolete and must be evaluated by case. It must be evaluated on case by case. Taking into factors such as right to life, personality, freedom of expression, and The famous case of water center, as I have stated with Einstein rightly. The other case was that the J. Barrett, that is President of Carolina, that is here versus Union of India, in which the Supreme Court of India issued some guidelines for telephone conversations, and the very famous case on our case is because of
कुछ भी नहीं बस बजाओ
in which I like that Paris was based on three tests.
आगे वापस
And
वापस गई
role in broadening the scope of the right, thereby ensuring that citizens are protected from unwarranted intrusion into their personal life. So this is the paper I have examined the historical background of right to privacy, the constitutional precedents that govern it. The law commission reports on the same, and I have discussed the role of judiciary. This right of this right. On the state as a fundamental.
Just a reminder to the participants that you won't be taking more than 5 minutes to stay on the set of. Next, we have Mr. Najib Khan with the topic data mechanics. So, a very good afternoon to one. This is Najib Khan. And the data social engineering of electronic conversation in order to dispense data like username, password, and credit card number. Phishing is primarily employed in email. And then we have this is very big. What is the whole thing? So most of with the attacker, then I want to give them personal information for login. Second, by looking into system information, the file then indicates the appropriate moves. Instruction ID. Third, won't be able to fourth, type of thing. Please what brilliant one by more Thank you so much, Minister. We next have Vatsali Srivastava and Akshay Tiwari to present their views on cyber technology or cyber crime and study.
A very welcome one or the pleasure of getting to you. So my name is Akshay Tiwari from Auntie Hockey. The topic that I have written this paper along with my co-author, Vatsali Srivastava. The one way right is the right, but very Now I would like to hand over the podium to my co-author, Vatsali Srivastava, to further explain the paper today.
Thank you, Akra. Respected dignitaries, I would like to further explain about the challenge. The cybercrime presents substantial as well as significant threat, because the crime is the lack of uniform legal framework is associated with substantial challenges. Public security in the fight against cybercrime. One drawback of information technology is that it has made it easier for criminal and antisocial behavior to take place online. Cybercrime is a fact of life. We must immediately address this issue and difficulty to get resistance. One of the most pressing issues that requires immediate attention is the issue of cybercrime. Cybercrime has no borders, so anyone can commit crime anywhere around the world. As a result, the the extent of societal dependence on information technology significant. The issue of jurisdiction is associated with numerous other issues. The ability of any agency to sanction a cybercrime is affected by the location of the activity. With regard to domestic and external jurisdiction, there are numerous issues that must be resolved. Now, I would like to further explain about the international law and cybercrime jurisdiction. International law and cybercrime jurisdiction, the component of state sovereignty that includes judicial, legislative, administrative, competent of the state sovereignty. The trans is very fundamental. Now, I like to conclude my speech. Terrorism is an act of threatening and terrorizing the form for the government in order to incite unpredictable violent conflict. For instance, the attack of the World Trade Center and the Pentagon in September 11, 2001. Further other attacks, including Mumbai, Kashmir, London, etc. Terrorism is available in the hands of weak individuals, a group of multimedia technology and new communication technology. I have discovered that the fundamental issue of cybercrime is substantive and procedural challenges. Different crimes have new, more sophisticated tools, thanks to information technology, and new types of crimes have also emerged. There is no human activity that is immune to cybercrime, regardless of whether it's financial or transactional and real. As for the treatment sections of IT and IT Act, moreover, there is no authoritative code including areas of ongoing community both even as the government is exercising intelligence, the company must provide its employees with cybercrime prevention and control training as well as specialized programs tailored to the needs of every segment of the life. Thank you so much.
Just a reminder to the participants, you only have 2 minutes time to speak on the said topic. Honestly saying, would like to bring a very crucial, clear line. In the past, cyber crimes are being carried out by cyber criminals. If cyber criminals use both knowledge most cyber crime results damage to an individual's device or the government. In the entire world, many of cyber crimes knowledge. Online that cybersecurity is present. Also, the handle for fix cyber laws. Nowadays, a lot of questions are being raised about cybercrime. To get answers for all of them, that is, search in the own watch. Some problem of cybercrime is in personal data, financial fraud, customer fraud, worldwide, providing fertile ground of hackers looking to cover cybercrime. Cybercrime is easy to learn. So how do I test
Good afternoon, everyone. The topic of our paper although Australian does not simply mention the right to privacy, it has been given a fundamental right to interpretation. This means that individuals have the right to know free from several viruses. The concept of privacy has not to personal interest, such as a person's name and free likeness, and personal correspondence from general authority exposure and commercial. USA, UK, technology, for example, suppose technology also highlights data about their online prices for some time later. The expectation of direct control over the healthcare information. The constant limit of the innovation to gather total breakdown, appropriate individual data combined with current strategic approaches and that individual security and protection. Expectation of privacy. The classification of a delicate data is tested by a legitimate system that provides assurances on who of the data, how the system is organized, and where information is put away and how long it is kept. The Indian laws that provide the right of privacy are the Constitution of India 1950, Article 21, which also includes phone tapping and right to privacy. Section 26 of the Indian Post Office Act 1998, Section 91 of CRPC, Section 3 of Indian Warning and Literacy Act, and Rule 138A of Central Motor Vehicles Act 1898. Protection of right to privacy in digital age. There are 4 ways in which privacy rights can be protected in the digital age: by preserving a consistent level of privacy protection for interaction, by raising the efficiency of right security plane for data transactions, by developing software that put a stop to the individually identifiable facts, by endorsing legislation and emerging new and start a process of command over private information during the business communication.
We next have Priya Srivastava and Kanti Gupta to throw some light on the topic. Especially right to privacy. Relating to survey program. 25 form the public. Privacy has to be. On their website, according to the report, government servers. Intended for the widespread adoption and legal approval of advanced encryption techniques. There is a need to build a culture of organizations are involved in the collection and personal data. Thank you so much. We next have Pratha Maurya to speak on the topic judicial interpretation on right to privacy.
Good evening to one and all present here. I, Pratha Maurya, pursuing LLB from Amity Law School, representing my research, which deals with concerns as a specific concern with respect to right to privacy. In general understanding, privacy is a principle that of individuals to have the space to exercise their free will and individuality against the world at large. Surveillance means closely observing important for the state to ensure national security and public order. However, there are certain contexts where surveillance can be done in a negative manner. Firstly, without the state taking action on this cause, there is a lot of but Citizens and co-citizens are easy and big challenges to right to privacy. Thirdly, the right to confidentiality. Among others, is most concerned as the fact and their whereabouts. Fourthly, demographic profiling is yet another consideration of personal data of people to target a particular community for the activity to gain their data privacy. That was the case of Cambridge Analytica. Lastly, another is was under the national in India. There being a thin boundary between the right to privacy and surveillance, there are many cases where our judiciary has interpreted the nuances of the same. Some of the landmark cases in this respect are Khalid versus Jacob, Muhammad and the regime of Telangana, case of Japan versus Union of India, or popularly known as 1997 UCA versus Union of India, Umakant Tripathi versus Ontario, and Shreya Singhal versus Union of India. All these cases are important in the aspect of the right to privacy. As such, I would like to conclude my paper that in a world where data and information have become synonymous, powerful, and their data protection and localization are essential. This is your right. Our people can enjoy the fundamental rights. Thank you. Lastly, we have Prabhakar Chakraborty to come up and speak on the topic emerging cybercrime.
Good afternoon, everyone. My name is Prabhakar Chakraborty. I am standing in front of you to present my paper on emerging cybercrime. So, what is cybercrime? Cybercrime, according to my understanding, can be defined as any criminal activity which takes place on or over medium of computers, through internet, and with other criminal technology. Cybercrime is the most powerful and effective crime which has a very destructive role in modern India. There are a huge number of illegal activities which are committed by technically skilled criminals. The main issue faced by the government is that they don't know who all are behind these cybercrimes, and due to advanced technology, most of the time they can't get caught. Cybercrime is not the latest one. It lasts long, which means forever. The most debatable topic is that we are not able to control the crime rate in the real world. So how can we control the crime rate in the virtual world where criminals are more educated and well trained? Earlier, it was difficult to attempt cybercrime because people were controlling the internet, but now the internet is controlling the people, and without the internet, our virtual world will be vanished. Cyber fraud and its impact on Indian economy. India is a major global community. The introduction, growth, and utilization of information and telecommunication technology has been accompanied by an increasing illegal activity. With respect to cyberspace, anonymous servers and emails and fake websites are being used as a tool and medium for fraud and cyber scams. In India, cyber frauds are also known as white-collar crime, and it is one of the major causes of poverty. The trend of white-collar crimes in India poses a threat to the economic development of the country. There are some type of cyber attacks like revenge pornography, online grooming, and cyberspace and interpersonal relationships. But the main concern is people talk about that India doesn't have any effective laws. So India do have effective laws, which are Information Technology Act 2000, which follows the Section 43, 66, 66B, 66B, 66G, and 66F, and also Indian Penal Code 1860. The sections such as 354C, 354D, and many more are there to prevent from the cybercrime. They are present. In the last, I would like to conclude that India can be secured, can be cyber crime can be controlled in India by social initiatives, scientific initiatives, and by non-government organizations. By social initiatives, I mean the understanding of human behavior, psychology, and sociology, and the scientific initiatives like privacy scanning and the help of scientific research to develop a more powerful and data secure management. And with the non-government organizations, we can promote the awareness in the society. And also, the present need by the Ministry of Electronics and Information Technology, Sri Ashwini Vaishnaw, told us that we need to overhaul our legal structure in a big way. I don't think. Thank you.
But this technique is incomplete without the presence of our esteemed guests. I will now like to call Professor Dr. Arpana Singh Ma'am to share her words of wisdom.
A very warm greetings to everyone present in the room. Respected director of the Amity Law School, Professor Yadav sir. Dear students, first of all, I would like to give my gratitude and thanks to the director sir for inviting me for chairing the session of this seminar. So the topic is of very relevance and contemporary, and I think I'm fortunate enough to chair the session with my teacher, Professor Asad Malik sir. So that would be a great feeling today. Thank you so much, sir. So far as experience is concerned regarding the session that I have chaired for the people, I find that Vatsal, Srivastava and Akshay Tiwari paper to some extent it is good. They have well discussed. Though the students have made their best efforts to collect content on the topic, but I would suggest them to make their presentation very assertive when the time limit has been prescribed and they have been confined with the time limit. So I think the assertiveness that is required for a presentation that is needed so far as my feedback and experience is concerned. This topic, if you see data protection and right to privacy, well, I think we are still far behind to achieve the objectives of the domain that is being covered under the right to privacy and data protection. If we see there is something which is private, something which is personal, is always protected, and to what extent? If we look the foreign laws on it, if we look at the European Union, for the first time, it has already covered the domain of right to privacy and data protection. The US has already come up with the regulation on it. India still has the bill on it. So we still have to achieve the, you can say, target that can set the domain of funding for the right to privacy and data protection. The courts are very conscious enough still to talk about the right to privacy issue, because we are entering into the 5th generations of the rights. We are now have come to that extent where we are talking about the IPR right, we are talking about the cyber laws right, we are talking about the right to information right. So somewhere when we are entering into the 5th world of rights, and where we are talking about the homosexuals right, LGBT right, where the European Court of Human Rights being so conscious enough in applying the doctrines on it,
the word, if I say, my learning colleagues who are present here, they are well agreed that how the court is conscious itself in applying the doctrines of margin of appreciation while pronouncing the judgments on homosexuality. Because something that has been covered under the rights to private domain under the Article 8 of the European Convention, I think that they take into consideration. So what my point is that even now when we are having, data issues related to the privacy issues, or you can say something that to what extent one can access your data, to what extent one can access your information. And we are already having the AI tools now. ChatGPT is already in you can say discussions that what can be the efficacies of this kind of AI when we have ChatGPT, when we have DALL-E coming up in our own way. And when we are saying that everything can be solved through these AI, ChatGPT is the century of the issues when we are talking about that it can help us be, human beings in getting access to justice. Where we can ask the questions from the AI, like ChatGPT, that how, that what sort of, legal things that could be asked from a council that AI can help it. So I mean to say it is also one way, a boon, when we can get help from these AI, in getting the access to justice. But at the same time, there is also, you can say, certain loopholes which can be targeted from the human points of view. So I mean to say this is such a domain where already the international framework is available. Getting the inspiration from international framework that already been quoted in various instruments we have under the regional instruments that we have, that how the bill is going to shape into the act which is already in existence. So that is the task of the, I think, Parliament that has still to take shape. And we hope that we'll come with some strong mechanism to curb out the issues that is related, whether it is in the cyber world, whether it is in the personal domain, or whether in any of the interdisciplinary areas that is related to law. So thank you so much once again for, I think it's really interesting. As I said, the papers were good, the students were good in collecting the content, and accordingly they have prepared. So I'll say that they have done work hard, at least some of them. So really the Savinaz paper was also to some extent good, which I can get it. Shraddha was good. And accordingly, Vaskal and Asha, congratulate to them for making some good presentation. Thank you.
Thank you so much, ma'am, for your insightful work. Now, I would like to call Professor Dr. Mohammad Asar Malik sir to grace the event with his words.
Good evening. First of all, I would like to congratulate Amity Law School for organizing this wonderful seminar on the very relevant topic. And I am thankful to Director Amity Law School, Professor Jaiprakash Yadav, for counseling and giving me this opportunity to come and share and all the teachers of the law school university who did very hard work, and all the students, committees and teams who are doing hard work for organizing the seminar, and also afternoon after session, they are here even against their wishes, but they are here to listen. And congratulations to all the paper presenters who come and even speak on these different things. And in future, I would like to suggest you have to make paper whenever you are deciding. There are three things should be in your mind. Number one, why you selected this paper. Number two, what is this area? Means the questions, research questions you can say. And then whatever the law and existing, and particularly the outcome, way forward, and the solution, incorporate whatever come in your mind. Now we are coming on the themes of this seminar. That is very beautiful souvenir was released in the morning. As we know,
title of the theme regarding the data protection, right to privacy, and particularly as we are talking about the digital era. We will see and go back in the ancient times. Professor Yadav might be aware about this lecture when we were in the LLM. Our Professor Shokatari was directly lecture on the law of thought regarding the right to privacy. And I tried to find out that case. And in 1907, that is the Abdul Rahman Bhagwan Das case, when the first time Justice Knox, Allahabad High Court, who recognized the right to privacy as a part of the custom, that is Parda system. If you will see that the movies लगे हैं शम्मा पर पहले जमाने की निगाहों पे, जिन्हें मिटने की हसरत है वो दीवाने कहा जाए। अब वो जो सर्विलेंस की बात हम कर रहे हैं, किसी तरह से कहते हैं कि किस कबूतर किस तरह ले जाए बामीनार पर, खत पर नामा लिखे और पर गिरे दीवार पर। खत कबूतर किस तरह ले जाए बामीनार पर, तो जवाब दिया जाता है कि खत कबूतर इस तरह ले जाए बामीनार पर ही पर नामा लिखे और पर गिरे दीवार पर। But this was the position. And now the position has totally changed. And Act versus Union of India 2021, Delhi High Court said the internet never sleeps, internet never forgets. Means every time you are under the scrutiny and data protection, to save the data is not so easy in the era of this present digital era. And it is to be said, अब वक्त बदला, जैसे कहते हैं वो आजकल हमसे भी करने लगे हैं ऑनलाइन अपराध, हमें ऑनलाइन देखकर ऑफलाइन हो जाते हैं। To me, the nature of enemy also changing. Then it also changing because of this era, which is changing very